Test, test. Good morning, everyone. Good morning, Judge Rovner.
Good morning. Good morning.
For many of us, this is our first day back in the courtroom since the new year began. So I want to wish everyone a happy new year. You may not be feeling so happy because you have an oral argument ahead of you, but I assure you we are happy, we are delighted to get to hear from you this morning. So let's get to it. We're going to begin with case number 1, 24-1081, Richwine versus Matac. Matac, you all can help me with that pronunciation. And looks like we have appellant's counsel ready remotely to begin. And one moment, please. All right, Mr. Comer.
Yes, Your Honor.
We are ready when you are.
Thank you, Your Honor, and may it please the court. I would like to first extend gratitude to the court for allowing me to appear remotely today, and I would like to reserve 3 minutes for rebuttal. Your Honors, the district court's preliminary injunction here must fall because Richwine is unlikely to prevail on the merits of her First Amendment claim in this lawsuit. The district court erred multiple times over when it enjoined the board from enforcing the cease and desist agreement at issue in this case. It erred when it rejected the state's procedural arguments, holding the state to an explicit waiver requirement that is unsupported by case law. It erred when it determined that all Richwine does is speak. It erred when it characterized Indiana's enforcement of its funeral licensing statute as a blanket ban on Richwine speech. And it erred when it chose to subject the state's statutes and its application of its statutes to strict scrutiny.
Mr. Comer, forgive me, Judge Rovner here. In your view, let's begin this way. Precisely what services could a deaf dual provide without violating the Indiana statute?
Certainly, Your Honor. We don't need to look further than Richwine's complaint in order to answer Your Honor's question. So Richwine engages in a number of professional services that don't require a license. She, according to the complaint, she says she directs clients to others in the death care community. She conducts visits with the dying and their families. She reads to dying clients, plays music, engages in conversation with them, performs healing touch, provides general companionship. She holds vigil while a client passes away. She assists in the preparation of legacy letters. She teaches families how to cope with grief. She provides services caring for dying pets. She mentors other death doulas, and she can advocate publicly about issues of death and dying, and none of that requires a license under Indiana's statute. And that's the bulk of the services I think that she offers her clients. Before we jump into the merits of the First Amendment issue,
how does what she wishes to do pose any risk to public health?
So certainly, Your Honor. So there are a couple of ways. So first of all, we of course don't have to prove that in this case that Richwine is misadvising clients. We don't have to prove that she's a bad actor. We have to prove that the state has an important interest in preserving public health. And as our affidavit from Investigator Calvert establishes, dead bodies, especially those that are already infected with infectious diseases, as they decompose, can spread infectious disease. And that's why the state has enacted burial requirements. That's why the state has established competency requirements and minimum qualifications for individuals who wish to perform these types of services. And Richwine, even though she's not the person who is going out and embalming a body, and she's not the person who's storing a body, and she's not the person who's burying the body, she is advising clients about issues related to the disposition of human remains. And that narrow form of counseling is what is implicated by Indiana's licensing statute in this case.
Let me pick on that question, because Ms. Richwine, in her settlement agreement, also agreed to refrain from sitting with the family and helping to pick reading, selections, scriptures, content for a funeral program. What is the harm to the state if Ms. Richwine is sitting with a family as they are sitting at the funeral home, making their selections for what a funeral will look like in terms of the content of the program?
So certainly, Your Honor. So a couple of things. I do want, of course, we recognize Your Honor's concern there. Part of it is going to come from the consumer protection angle. A lot of the services that Richwine is offering are duplicative of services that funeral directors are already going to provide, that they are legally required to provide. And in those circumstances where you have somebody who's essentially creating a middleman type of situation, in addition to the funeral service provider who's already, coordinating different vendors and things of that nature, it does create the potential for fraud. It does create the potential for negligence. And so it makes sense that the state would want to step in and govern that. Yes, and so that is part of it. And certainly that does not relate back to the public health rationale, but it does relate to the consumer protection aspect of it. And in addition to that, Indiana also, a lot of those things that Richwine's going to be doing in that situation, helping the family select funeral goods, helping the family, figure out perhaps what is most cost effective. Those are things that are governed under Indiana statute, and that funeral directors have a duty of candor in order to provide. And so I believe we cite the statute in our brief. It's Indiana Code Section 25.
But my question wasn't about the parts that cost. When a family is selecting what music to play at their loved one's funeral, what scriptures to read or poems, what reflections, who's going to speak on the program, none of that involves cost. Where is the potential for fraud?
Certainly, Your Honor. So, but even if the court is inclined to say that there are certain things that fall outside, that Richwine has agreed to in this case, that fall outside of the state's interest, I think the injunction in this case is still much too broad, because there are things that she's doing that undisputedly constitute the counseling for the disposition of human remains, and Richwine doesn't contest that at all. And so even if the court were to believe that some parts of the cease and desist agreement might not be able to satisfy intermediate scrutiny, the preliminary injunction the district court issued here is still far too broad, because it bars the state from enforcing any aspect of the cease and desist agreement. And in addition to that, Your Honors, I do want to briefly touch on the issue.
Before you do, tell me this. Is the finalized cease and desist order an inaccurate representation of the Indiana statute scope?
No, Your Honor, I don't believe that it is, and I don't believe that we can contest that, because we and Richwine have both agreed that the specific services listed in paragraphs A, B, and D of the agreement do run afoul of the licensing statute.
Well, then how did the revisions constitute a waiver? If your answer is no.
So it's not just Richwine's revisions that we believe constitute the waiver. It's not Richwine's admission to the violation either that we believe constitutes the waiver. Our position is that it's Richwine saying that my conduct violates Indiana's funeral licensing statute, and I'm agreeing to cease and desist engaging in that conduct. I'm agreeing to, essentially what she's saying is, I'm agreeing not to speak when she enters the cease and desist portion of that agreement. And that is consistent, and our position is consistent with what the Second Circuit has found in Romero. It is consistent with this court's precedent from George F. Nord Building Corporation, and it's consistent with...
Well, here's what I'm trying to figure out, Mr. Comer. How did plaintiff's revisions to the cease and desist broaden its scope?
So
before plaintiff's counsel revised the cease and desist order, it prohibited plaintiffs from counseling consumers in any manner and through any medium required. How did any revision that was made broaden that scope? How could you possibly broaden it?
Sure, Your Honor, and I take Your Honor's point, and if it didn't broaden it, it certainly added specificity. So Richwine adds the provision, so there's the part of the agreement where it says respondents shall refrain from counseling consumers, and Richwine adds the provision saying in educational events open to the public. And so that is the part where she specifies that these educational events, I think that is where maybe if it doesn't broaden, it certainly targets the agreement towards public educational agreements in a way that it...
Why did you sign it? Why did Indiana sign such a thing if you felt this way?
Well, we signed the agreement because we believed it was a final disposition of the issues in this case. And
well, but who signs an agreement if it doesn't match your desires?
Well, I want to take a step back. We don't concede that the agreement doesn't match our desires. I apologize for the double negative there. But my response to Judge Jackson Akarumi's question was really an alternative argument that even if the court disagrees with our reading of the entire order, that it should still narrow the injunction that the district court issued in this case.
I'd like to take you somewhere else if you don't mind, because you're going to have to help me with this. How does the board provide an adequate opportunity for plaintiffs to raise constitutional issues?
Certainly, Your Honor. And so
I'm sorry, I think I should be saying challenges, constitutional challenges.
Certainly, Your Honor. And I want to preface my response here by saying that our abstention argument really is a secondary argument. We believe as Your Honor, I'm sure is aware, we believe our waiver argument is our first and our best procedural argument. But the board provides an adequate avenue for constitutional challenges because I believe it's in this court's decision in Mulholland. The court recognizes that the opportunity for subsequent judicial review of a decision is an adequate opportunity to raise the constitutional issue. And so it's our position that had Richwine not agreed to cease and desist, that she could have continued to litigate the issue on judicial review, at which point a court could have weighed in on her decision or on the constitutionality of the board's application of its statute.
Okay, well, why would I be wrong if I thought that under Holder, it seemed quite clear to me that the Indiana statute is regulating speech and not just conduct. Do you want to help me with Holder?
Sure. I don't believe that this is really a Holder issue. We're not contesting the idea that in most circumstances, a content-based restriction on speech is going to be subject to strict scrutiny. We see this as a NIFLA issue, where under NIFLA, the court says that generally that same rule is going to apply. There is no professional speech doctrine, but there are exceptions, and one of those is when the state's regulations regulate speech incidental to conduct. And in those circumstances, then a lower level of scrutiny applies. And so the issue in this appeal is whether the state can satisfy one of the NIFLA exceptions. And if it does, then the district court's application of strict scrutiny is incorrect.
Okay, so here's the situation. This law does not compel disclosures, nor does it only incidentally involve speech. The focus of this statute, it seems to me, is on who can say certain things, so that the law applies to speech is its purpose, not its unintended product. That's why I lean toward believing that strict scrutiny applies to the restrictions that have been placed on plaintiffs' non-advertising speech. And you need to provide, Indiana has to provide, a compelling government interest. And you've been, in your brief, certainly pointing to the public health concerns, which I'm trying to figure out. So anyway.
Certainly, I'm running short on time. May I respond briefly, Your Honors?
I would hope so.
Thank you. So just really quickly, I think if we look at what other circuits have held in Ritter and Del Castillo, we look at the overall aim of the statute. And in Indiana, our funeral licensing statutes are aimed at the conduct of funeral services providers. And they only incidentally sweep in counseling regarding the disposition of human remains, which we believe constitutes both conduct and speech. Thank you, Your Honor.
All right. Thank you, Mr. Comer.
Thank you, Mr. Comer.
We'll give you a few minutes on rebuttal, Mr. Comer.
Thank you.
Mr. Field, welcome to the podium.
Bless you.
Thank you.
Thank you, Your Honor, and may it please the court. Benjamin Field for plaintiffs appellees Lauren Richwine and Death Done Differently. I'd like to cover three basic topics this morning. First, the level of scrutiny that applies. Second, how to actually apply that. And third, touch briefly on the procedural issues. So first, to pick up on the level of scrutiny, I think that Judge Rovner has this exactly right. If you look at what is actually being restricted from Lauren's, what she's being restricted from doing, it is entirely speech. So if we look at the cease and desist order itself, that's document 11 below, paragraph 17A, B, and D lay out what's prohibited. It's discussion of funeral options. It's assistance with paperwork. It's verbal guidance. It's consultation with a family. It's accompanying a family to a funeral home to discuss things about funeral services. Indiana's reply brief at pages 13 and 15 lays out what they think is prohibited, and it's entirely speech. And so as Judge Rovner was suggesting, this is solely speech that's at issue. And it's correct that under Humanitarian Law Project, that means that the government is restricting communicating a message that triggers strict scrutiny. This is just the analysis that Judge Ramirez applied in the Hines case that we submitted a 28J letter on. I think this is a very straightforward case of strict scrutiny. And NIFLA is not any sort of exception to the Humanitarian Law Project rule. In fact, NIFLA, in its discussion of speech, cites Humanitarian Law Project. NIFLA is simply saying, if you're regulating conduct, that's different. Obviously, the First Amendment doesn't reach non-expressive conduct. That's all that NIFLA is saying. But NIFLA reaffirms Humanitarian Law Project's basic instinct that when it is speech and the content of speech that is being targeted, that full First Amendment scrutiny applies, and that there's no exception for so-called professional speech or just because the form of the law comes in a licensing regime.
But you do take the position that you win under either level of scrutiny, is that right?
Yes, Your Honor. And so I'd just like to go straight to that. So, you know, in terms of actually applying the scrutiny, I think that the government is asking for what's effectively rational basis review. And I think we all have to agree that when we're targeting speech based on its content, that cannot be the case, whether it's intermediate scrutiny or strict scrutiny. And so I'd urge the court to look at Hines, to look at Edwards, to look at Billups, other cases that said you don't need to decide the intermediate versus strict because the government failed under intermediate. And they're looking at real arguments and evidence that the government put forward and show why the government wasn't able to satisfy intermediate scrutiny. Here, we have absolutely nothing from Indiana. If you look through their briefs, I don't think that you're going to see any argument on why Lauren's speech needs to be restricted until the end of the reply brief. And basically, they just think that two things on her website could have been phrased a little bit differently, things that the district court found were true and unharmful. And so if we just do the actual intermediate scrutiny or heightened scrutiny, however you want to look at it, I think that the questions that Judge Rovner and Judge Jackson-Nakawumi were asking my friend really get at this. So first of all, when it comes to what interests they think that they're advancing, I heard Mr. Comer say two. One was consumer protection, and he just said, well, funeral directors also talk about these kinds of things. I mean, I think that's just an admission that Indiana's interest is paternalism, that they don't think that a family who wants to hear Lauren's advice should be able to hear the guidance that she wants to give them because they could go to a funeral director instead. I think that Sorrell teaches that kind of speaker-based targeting, to say the government wants certain types of speakers to talk about a topic, but not other types of speakers, is the core of what the First Amendment is targeting. I mean, that is, I think, viewpoint discrimination, the most odious form of speech restriction in First Amendment law. And they have no actual evidence that a consumer has ever been harmed by Ms. Richwine's speech, that a consumer has ever been harmed by end-of-life doula speech. And it's frankly hard for me to understand how they would come up with such evidence, even though they bear the burden to do so under heightened scrutiny, because she's giving just the kind of advice that families want. She goes with them to a funeral home to make sure that there's a disinterested person there, to make sure they're selecting services that really serve their family's interests. She's sitting down with them to make an end-of-life plan, to ask the person who's dying, what do you want? What do you want? How do you want to be remembered? What songs do you want at your memorial service? I mean, I just do not understand the government's argument that there's a consumer protection rationale.
Although I do take issue with your characterization that she's disinterested. She's not disinterested. She's been paid by the family. It's just that she is the person the family has selected to walk with them through this process. It makes her very much interested, but it makes her the choice of the family.
Yes, Your Honor. I just meant that she was disinterested in the sense that she's not trying to sell them an expensive casket or upsell them on burial services. I
understand. I do want to talk about waiver.
Okay, Your Honor.
Although my colleagues may want to go back to the merits. Now, Ms. Richwine, in this cease and desist agreement, she agreed that her services constituted the practice of funeral services.
Yes, Your Honor.
At least the 4 itemized things. She agreed she didn't have a license to practice, to provide these services. And she agreed to refrain from providing those services in the future. So how is that insufficient to establish knowledgeable waiver?
So I was with you until the last thing, Your Honor. I do not believe that she ever agreed to stop providing these services. So if we actually look at the waiver provisions...
The enumerated services.
That's correct, Your Honor. So if we look at the waiver provisions, what she says in paragraph 11 is she defines the specific things that she's going to waive. And this is document 11 from the district court record. So she says that she's aware of her rights under Indiana law, including the right to a hearing before the board and what that entails. She identifies the right to rehearing and judicial review of the board decision under Indiana law, the rights afforded by Indiana's Administrative Orders and Procedure Act, and all other applicable Indiana law. And then paragraph 12, which is the actual waiver, she says that she agrees to waive each of these rights under Indiana law to terminate the proceedings. So I think the only thing that she was waiving was her right to a contested hearing and to appeal it under Indiana law, under Indiana administrative procedures. And so I think by including those express terms, it excludes all of their waivers. Now, the government suggests that by agreeing to the cease and desist order, that she agreed to comply with its terms and never to challenge it. But there's just no language in the agreement that reaches that. So if you look at paragraph 30 of the agreement, what it says is that the parties agree that the board may, without further notice or formal proceeding, issue the following order. And then there's the cease and desist order. But that's an order from the board. That's just affecting the waiver of a contested hearing. So she's saying, look, It is, if you just look at the statutes, they are clearly broad enough to reach my conduct, so I'm not challenging the application. It is true that I give people guidance about end-of-life options. That seems to fall within the statute. I'm not going to contest. The board is accurately describing what I'm doing. I'm not contesting that Indiana law says I need a license to do it. And so she's simply saying, yeah, as a result of that, I'm not going to go through a fruitless contested hearing. You can enter this order. But she never agreed not to challenge that order or even to follow what the order says.
It seems to me when you look at paragraphs 20, 21, 22, 23, she is saying she's not going to do this stuff anymore. She says in paragraph 20, she took numerous actions to address unlicensed practice. Paragraph 21, she stopped taking new clients. Paragraph 22, she's altered the services she offers to the public. 23, she no longer advertises the services set out from above. How is that not an agreement properly read as an agreement not to do the things that they've outlined in the order?
So I think that it cuts just the other way, Your Honor. She is saying that she has stopped doing those things, but there's no promise anywhere in this agreement that she's not going to do them in the future. And I also think that this supports our position because what this is saying is that she was chilled not by the cease and desist order itself. She was chilled by the Attorney General's enforcement. And so the cease and desist order is simply terminating the state proceedings. The chill preceded it. The chill comes directly from the statutes, and it's the statutes that we're challenging here. I think the logic of Indiana's position would be that if Indiana repealed all of these statutes tomorrow, that Lauren would still somehow be bound not to speak. And I just think that cannot be right. It's certainly not the kind of, there's certainly nothing in this that is a clear and express waiver that's that extreme.
Well, let me ask you about the last page, page 8 under acceptance. There she says she understands this is a final disposition and is not subject to further review. There, we don't have the language we see earlier in the paragraph that says further review under Indiana law or further review by the board. It just says not subject to further review, full stop. And then I enter into this agreement voluntarily, knowingly, and intelligently. So forget everything that happened on pages 1 through 7. How is page 8 not a waiver of further review by anybody?
So sure, 3 responses, Your Honor. First, I think that has to be read in line with paragraphs 11 to 12, where she's very clear that it's only Indiana law waivers. Second, I don't think that this proceeding is challenging the board's order. In fact, we accept that the board was correct about Indiana law. So I don't think that this isn't a situation where we're seeking to undo the order. We accept its correctness. This is instead a prospective challenge to the Indiana statute saying the board was right about what the statutes require, but that's unconstitutional. And so as I was just discussing, I think this is akin to, we're asking the federal court to enjoin enforcement of the statutes. That's as if Indiana just repealed the statutes tomorrow if a court says that they're preempted. And finally, Your Honor, I think, the government has pointed to the drafting history, and I think that this is actually quite instructive on this specific provision, the acceptance provision. So if you look at the red line the government put into the record at document 2611 below, there used to be language in that section that the government proposed where Lauren said she agreed to be bound by the board's order. We took that out, and the state agreed to that. And so I think that this is, the state in their brief repeatedly accuses Lauren of, signing an agreement behind her back. But this was a negotiated agreement between Lauren and the small business she runs out of her home on one side and the sovereign state of Indiana represented by the full force of the Attorney General's office on the other. And we're simply trying to hold the Attorney General's office to the bargain that it struck. And there is nothing in there that waives Lauren's rights to exercise her First Amendment rights or to assert them in federal court.
Let me ask you one more question about waiver. Does a waiver have to specifically reference a constitutional amendment, the constitutional amendment that the abandoned right flows from, to be valid and enforceable?
No, Your Honor, but it does have to be clear and convincing. The court should indulge every reasonable presumption against waiver. And so I think in a case here where the waiver provisions are just incredibly narrowly focused on Indiana procedural rights, and Lauren never made any promise not to speak, I think that at the very least this is ambiguous and that the court should read the agreement in a way that doesn't eviscerate Lauren's rights without an express waiver.
And that would be, I take it, your argument would be because as applied to Ms. Richwine, whether or not she's permitted to speak to her clients depends wholly on what she is saying. And she is restricted from providing any education, any advice on the topic of death.
That's absolutely correct, Your Honor. This is the core heartland of Humanitarian Law Project, where the government is restricting what she says because it communicates a message, because it's giving advice. Humanitarian Law Project, and as Judge Ramirez explained in Hines, in the specific context of occupational licensing, in this situation, strict scrutiny applies. But even under intermediate scrutiny, the last point I'd like to get to is just the tailoring component of it. I'd just like to remind the court just how onerous these licensing regulations are. For Lauren to satisfy the two licenses, the funeral director license and the funeral home license, she would have to buy a funeral home that she would literally never use. She would have to go to mortuary school for a year, and she would have to then be a funeral intern for a year, embalming 24 bodies that has nothing to do with her practice. And so even if you set everything else aside, just doing intermediate scrutiny and just looking at tailoring, I don't think that there's any argument from the state in its briefs here, in Mr. Comer's presentation, or in the briefs below that explain why those incredibly onerous regulations are in any way tailored to whatever interest the state has in restricting Lauren's speech. If there are no further... I'm sorry, Your Honor.
I do have... Do you view Ms. Richwine as a rent-a-friend, basically?
I think that is one way you can look at her. I mean, I think she provides the same kind of advice that a friend or a family member could provide. But, not everybody is used to going to a funeral home to pick out services. And so families understandably get a lot of value out of somebody who's used to this, who's used to dealing with grief, to provide that kind of support. And they just want someone to talk to about these important choices. If there are no further questions, I'd urge the court to affirm the preliminary injunction.
All right, thank you, Mr. Field. Mr. Comer, we were questioning you pretty actively, so we'll give you the 3 minutes.
Thank you, Your Honor. Just a couple of points. First of all, regarding waiver, I want to mention, it appears that Richwine's position is that she gets to excise the cease and desist order from the agreement and hold that out as being an action taken unilaterally by the board. And that's not, that's just not correct. The cease and desist order is part of the four corners of the agreement. Ms. Richwine's signature appears 2 times on the very next page. The language was in the draft that was circulated to her, and she had the opportunity to negotiate it. And so the cease and desist order is part of the agreement, and it's Richwine's agreement. So when the agreement says that Richwine agrees that the board may issue an order that she shall refrain from counseling consumers and that she will cease engaging in the professional services articulated in paragraphs 25, 1, 2, and 4, she is agreeing essentially to stop speaking. She is agreeing to terminate the professional services that that are at the very heart of this lawsuit. And that's based, and that is, that's remarkably similar to what the Second Circuit was confronted with in Romero. And opposing counsel has mentioned, that the waiver provisions only pertain to state law, and we don't disagree that those particular parts of the agreement are waiving state procedures, state rights. The source of the waiver for the purposes of this case, though, comes from the cease and desist language. It comes from the acknowledgments at the end where Richwine says that this is a final disposition and is not subject to further review. And in Romero, what we had was an individual who was subject to an action taken by the SEC And the agreement there said defendant understands and agrees to comply with the SEC's policy. So it's just talking about an administrative agency's policy, not to permit a defendant to consent to a judgment. And there the court says, concludes by saying, to the extent, because of that language, to the extent that Romero had the right to publicly deny the SEC's allegations against him, he waived that right by agreeing to the no deny provision as part of the consent decree. And that is essentially what Richwine did here when she agreed to the cease and desist provision as part of the settlement agreement in this matter. If there are no further questions, Your Honor, the state respectfully asks that this court reverse the preliminary injunction.
All right, thank you, Mr. Comer. We thank both the parties, and we will take the case under advisement. We turn now to the second case of the morning, appeal number 23-3094, United States versus James Weiss. Okay, so we have Mr. Yusharovich at the stand. You can correct my pronunciation.
Good morning to the court. Attorney Ilya Osharovich on behalf of the defendant, appellant, Mr. James T. Weiss. Your Honors, this case tests whether federal agents exceeded their limited authority when they interrogated Mr. Weiss, who was detained pursuant to a search warrant without reading of Miranda rights. In Michigan versus Summers, the United States Supreme Court held that search warrant detentions are not likely to be exploited by the officer or unduly prolonged in order to gain more information, because the information the officers seek normally will be obtained through the search and not through the detention. In United States,
if we find that Weiss's interview with the FBI was voluntarily given, does that necessarily mean that the interview was not unduly prolonged?
it was unduly prolonged. Even if you find it's voluntary, it's still unduly prolonged, but the court can't find it's voluntary because all of the actions were directed by the police department and they completely by the law enforcement agency, and they completely dominated the environment. So it can't be considered voluntary. Mr. Weiss was seized pursuant to a search warrant involuntarily. And I'll get to that part in explaining it. For example, in United States v. Burns, this circuit held that absent special circumstances or possibly a prolonged detention, in the usual case, a person detained during the execution of a search warrant is not in custody for purposes of Miranda. Here, there are special circumstances in that Mr. Weiss was the actual target of the search warrant. Unlike Matac, Summers, and other cases, they were just seizures of people who were present on the premises to be searched. Here, Mr. Weiss himself was the actual target. His body and his person was to be seized and searched. Moreover, the questioning of Mr. Weiss was not limited in scope and duration to officer safety, to evidence, or opening doors. It went beyond. It was solely eliciting, it was designed to elicit incriminating testimony without Miranda. And there was...
How do we deal with the fact that the agents approached Mr. Weiss after, he pulled over and said they had some questions they needed to speak to him about, and he said, sure, and asked if he needed to step out of his vehicle.
Well,
then he did, and he went and he sat in the car.
Well, that again, the initial seizure was involuntary. So what they did was they gave a show of authority. He then submitted to that authority and was no longer free to leave. If he tried to leave, he would have violated federal law or state law. Then when they directed him, they told him you have to move your car to another location. He responded to that. There was no voluntary action. He complied with their orders. Then they told...
he repeatedly stated that he wanted to cooperate with them.
Correct.
And of course he left to retrieve his phone, and returned.
Well, the issue is that when they approached his car, they used the word need. They didn't say, "Hey, Mr. Weiss, can we speak with you? Hey, do you have a chance to talk to us?" They said, "We need to talk to you." So given the show of authority, the removal to another location, then telling him we need, he says, "Okay, sure. Do you want me to get out or not?" He's asking, "What do you want me to do?" in response to their command. They then tell him to get out of the car, which is his orders, the officer's orders. He gets out, and the key thing is they told him to disable his vehicle. So everything he did in response was to their actions. But addressing the part where he says, sure, I'll voluntary talk. Everybody is voluntary talking when there's a Miranda warning. I mean, when there's a Miranda issue, that's the whole issue. They gave statements, they all talk voluntarily. But here, that voluntary statement came in the middle of the interview after it already started, before they gave a Miranda. So when you go back...
Counsel, I'm looking at the transcript from the initial encounter here. So Agent Heidi, we need to chat with you about a couple things. Weiss responds, "Sure. Do you want me to get out of my car?" Heidi responds, "If you want to jump in the back and get in with us real quick, you're not under arrest or anything like that." And then he continues, "We just have a couple things we want to talk to you about." So I want to tease out that language because there was a clear statement by the agent, "You're not under arrest." Is it your view that the use of need a couple seconds before erases that? Because clearly the agent said you're not under arrest.
Well, right. But that also, whether he was under arrest or not, that's just a talismanic statement, because during the trial, the officer said he wasn't free to leave from the moment we stopped him until that search warrant was executed. And they deviated from the search into an interrogation. So it changed the nature of the underlying search. So whether he was under arrest, that's not the issue. The issue is he was seized pursuant to a search warrant. He wasn't free to leave. And it is akin to a formal arrest. But
And when you say he wasn't free to leave, you're basing that on the verb "we need to chat." What are the other circumstances?
there was a show of authority that he submitted
Show of
to,
authority,
which is the activation of the lights.
that the lights is what you're
Right.
talking about.
Well, that's one part.
Okay.
Then the moving him to a location, directing him to go somewhere, right, of their choosing, so that the public would not be any wiser. They secluded him from the public by choosing those locations. Then they moved him to a third location, which was a mobile interrogation room, which is the police car. In the police car, they told him those statements, but he still wasn't free to leave. It was, and the agents admitted that. They said until that search warrant was fully executed, he couldn't leave anywhere, because they stopped him, one, pursuant to the search warrant, two, they were worried he was going to destroy evidence. And even though he was allowed to walk out of his car to get his phone, the entire time the agents were next to him. And that's the same thing in Matac Carey. The agents were with him the entire time. But here, there's another issue, is that the questioning, we don't just look at the detention. See, and that's what I was trying to get to. For example, other federal courts addressing this issue have faulted law enforcement agents for exceeding that limited authority granted in Summers when interrogating suspects who are seized pursuant to a search warrant. In Matac Carey, the First Circuit held such questioning without Miranda must be limited to seeking identification, verifying, dispelling suspicions of criminal conduct, or maintaining the status quo while obtaining more information. The First Circuit held that a suspect who's seized as an occupant of the premises subject to a duly issued search warrant is entitled to be free from excessive questioning intended to elicit incriminating statements or information. So in Kim, in the Ninth Circuit, the court found that asking more than a few questions to determine a person's identity or dispel the suspicions of criminal activity is beyond the scope of the lawful detention prescribed by Summers. And then in Knapp, this Ninth Circuit went further and found that a seizure becomes unlawful when it is more intrusive than necessary, and it prohibits officers from exploiting the seizure to obtain more information than normally would be found in a search. Hence, the spirit of the law throughout the entire country is that the questioning without Miranda in a search warrant situation must be limited in scope and duration. The scope of the detention, forget that there's an interrogation and detention, the scope of the detention must be carefully tailored to its underlying justification. Since the justification for a search warrant detention is to prevent the suspect from fleeing the scene, to ensure the safety of officers, and to help facilitate an efficient and orderly search, the detention of the target of a search warrant, like Mr. Weiss, he wasn't just an occupant of the premise, he's the actual target. These same standards have to apply. So here, the extensive interrogation at issue didn't support any of these factors, and the questions were not limited in scope and duration. Therefore, the interrogation of Mr. Weiss, whether he was voluntary or told he's not under arrest, was not carefully tailored to the detention's underlying justification. So it was more intrusive than necessary. And that's where the Ninth Circuit combined the Fourth and the Fifth Amendment kind of, to summarize it with, they took Summers and they combined it there so that there isn't an exception to Miranda that's carved out. And that's what the district court did here. They carved out an exception to Miranda in search warrant cases. And that's a big issue. So there's also...
I'd like to take you just a little, because time flees and we have a couple of issues here. But are you arguing that the contents of Mr. Weiss's phone should be suppressed?
We are arguing that the contents of the phone is not really our dispute, it's the actual statements. The contents of the phone really had no evidence on it that was used at the trial, so it's not really that important to us. It's the actual statements, because those statements were key to the false statements charge and to the honest crimes and the bribery and the wire fraud. But and this goes back to what Your Honor asked me. There's no question Mr. Weiss was in custody. The entire context of the questioning, including the place and length of interrogation, demonstrated that the course of investigation was police dominated. Here, the police assumed complete control over the interrogation site and the course of conduct followed by the defendant. They chose the location to stop. They chose when to activate their lights, forcing Mr. Weiss to submit to their show of authority. This wasn't a restaurant where someone's on the Gold Coast and they stop someone and say, hey, can we talk to you? They physically pulled them over with a show of authority and a search warrant. So,
well, what do you think would have occurred if he had not repeatedly stated, I want to cooperate with you?
Well, that's irrelevant because, again, the officers were only allowed to stop him to search his person and take the phone. That was the justification for the detention. They went beyond that when they deviated into an interrogation. So even if he said, I want to cooperate, that was mid in the interview, but he still has to be given his Miranda warnings. Everybody talks. Everybody, when they're asked questions in custody, the people answer the questions, then a motion to suppress comes. So they're always voluntarily speaking. But to make sure that it's voluntary, the Supreme Court said we have to give these people the rights so that they understand and they're aware of their rights, and so they're not taken advantage of by law enforcement.
What about Mr. Weiss's comments, I'm not a rookie? That he was willing to cooperate, wanted to cooperate. I mean, he seemed to have an understanding that he could go, no?
No, I don't think he had an understanding that he could go, but I think when he says I'm not a rookie and those things, that doesn't matter because the Fifth Amendment and the Fourth Amendment are there. Whether you're a rookie, whether you're a pro, whether you're a little kid, you still have those rights. They don't disappear based on your education level or how smart you are or how many times you've been involved in the legal system. These are the rules. This is how it works. And so one of the things that, and I've gone through what they, the FBI admitted he's not free to leave. Once they seized him, he's not going anywhere. So that brings the idea that the best way to keep someone in prison is to make them think they're free. And we can't have the officers hiding search warrants from their targets to get interrogations. And so it's important. This is probably one of the more important parts, and then I'll stop because I did reserve only 5 minutes for this argument and then 10 rebuttal. But it's important to note Mr. Weiss was the focus of the search warrant and the investigation. And this awareness contributes to the sense of custody. This case has to be distinguished from other cases where being the focus of an investigation was only given minimal weight, since the individuals in those other cases were just occupants detained on the premises to be searched. Here, Mr. Weiss was made aware of that the agents were looking into his interactions with the Royal, and he was actually the target. This is not like Summers where they come to a house and they find someone who's present in the place. Mr. Weiss was ordered to be arrested, searched, and seized and released. And what I mean by that, arrested for purposes of the search warrant, to be seized. So there's no question he was in custody and they elicited incriminating testimony. All they had to do was just read him his Miranda or execute the search warrant. And going back to what Your Honor wrote there said, the issue is they prolonged this detention. It should have only taken 10 to 15 minutes to take his phone. Instead, they spent an hour and a half because they deviated from the search. They began it, they executed the search warrant by stopping him, and then during the search, they just went into interrogation. The warrant only allowed them to seize and search him, not interrogate him. So Affirming the district court in this matter would carve out an exception to Miranda and search warrant cases, which would be contrary to our sister courts and to our sister circuits and the Supreme Court in Summers, which found that a search warrant detention is not likely to be exploited by the officer or unduly prolonged in order to gain more information, because the information the officers seek normally will be obtained through the search and not through the detention. And that's what happened here. They used the search, they used the detention to get more information than they would from the search. And that's exactly what the United States Supreme Court prohibited. There's just no case that we found that addresses when the target of the warrant is seized.
Isn't the length of the interview attributable to Mr. Weiss's voluntary cooperation with the agents?
No, it is not. It's because the length of the interview, again, it was them asking him questions involuntarily. They put him in a car, they pulled him over, they seized him, and they deviated. But again, the courts have held that anytime someone is seized pursuant to a search warrant, they have a right to be free from being forced to question, to obtain illicit or to obtain incriminating statements. So basically, the First Circuit has said that a person who's seized pursuant to a search warrant that's based on the premises, when they find someone on the premises, is entitled to be free from excessive questioning, entitled to elicit incriminating information. So whether it was voluntary...
Are you arguing, by the way, that the existence of a search warrant made Mr. Weiss feel like he could not leave?
No, not at that time, because he didn't know about it. But the existence of a search warrant is the responsibility of the officers to not deviate past the justifications in that search warrant. So cooperation or not, he had a right.
So you're trying to say that if the officer has the warrant in their back pocket and they ask the person, will you speak with us or will you answer our questions, that they cannot do that if the person consents,
Well, there's a difference. What you're saying is the warrant's in the back pocket and the person wasn't seized pursuant to the warrant yet. Once those lights came on in the police car, that warrant came out of the back pocket. He was in custody, and at that time, he was to be free from excessive questioning intended to elicit incriminating information. So if this court affirms this district court, they will carve out an exception to Miranda and search warrant cases, contrary to our sister circuits and Summers. If he was just a premises occupant, where they raided a house and they found someone sitting there who's not on the search warrant, then he gets less protections. But here, when he's the actual target, there's no question that he gets these protections. So I used all my time, but this was our main issue. So at this time, I think we're completed.
I suspect we'll want to hear from you again, Mr. Usarovich, so you'll be back.
Thank you.
Okay. Ms. O'Neill.
Thank you, Your Honors. May it please the Court, Christine O'Neill on behalf of the United States. The District Court committed no error denying defendant's motion to suppress his statements to law enforcement. The question before the District Court was whether the defendant was in custody and should have been Mirandized, and the Court applied the correct legal standard, citing United States v. Patterson, which is whether a reasonable person in the defendant's position would have believed he was free to leave.
May I stop you, because I'd like to ask you about, the initial stop. What level of suspicion did the FBI agents have to have when they initially pulled Mr. Weiss over, and what precise evidence exists in the record to show that the agents had that requisite level of suspicion?
That is a very interesting question, Your Honor, that was not briefed before the District Court because no one was challenging the search warrant that was lawfully issued for the defendant. I would say, though, that the officers also had reasonable suspicion here to stop him based on his involvement in the crime that was laid out in the search warrant affidavit. But as this was argued below and presented to the District Court, the stop was pursuant to the lawfully executed search warrant. That doesn't change defendant's ability to voluntarily consent to an interview with law enforcement. As Judge Maldonado was asking Mr. Usharovich, law enforcement is allowed to talk to someone despite the fact that they may have a search warrant in their back pocket. There were no disputes in the record about the facts here. Defendant never asked for a hearing on these issues, and the district court found that the defendant voluntarily accepted the invitation to join the FBI inside their vehicle. The defendant was never physically restrained at any time. He was told he was not under arrest. He was told twice that the interview was voluntary. And as has already been discussed this morning, the defendant said 3 times that he wanted to cooperate throughout this 90-minute interview.
Can you respond to Mr. Usarovich's argument that the warrant was not in the back pocket? They activated the warrant, and at that point, there is a concern under the case law about prolonging, et cetera, and his argument that we would be carving out an exception under Miranda.
Yes, Your Honor. There is no doubt that the FBI stopped Mr. Weiss pursuant to that search warrant. He was pulled over in order to execute the search warrant. But then they initiated a voluntary conversation with him, and that is what makes this different than the cases that defendant cites where a search warrant is being executed. Those cases that Mr. Usarovich is arguing about are almost every single one of them involves the FBI or law enforcement breaking down a door at 6 a.m. In Matac, it was 8. In one of the other cases, it was 20 law enforcement flooding a person's house, guns drawn, and then they put the person on the couch and say, "You're free to go. We just have a few questions if you want to answer them." That is a very different situation than what happened here with Mr. Weiss. The cases about prolonging an interrogation while executing a search warrant do not apply because the agents here were not executing the search warrant throughout the encounter. They did stop him pursuant to it, but then they proceeded into a voluntary encounter that the defendant prolonged repeatedly. He never asked to leave the vehicle. His statements themselves reflected the voluntariness of the conversation. He makes jokes with the agents about borrowing money from them. They could have followed him to his lunch meeting and paid for the meeting. He says, "I'm not a rookie." He says, "I have nothing to hide." On the issue about, I'm sorry. Oh, I thought I heard Judge Rosner. My apologies.
I think so. Judge Rovner, were we?
No, I'd like her to finish.
On the issue of whether at trial, Special Agent Heidi testified that the defendant was not free to leave, I think if you read through the cross-examination and the redirect, it becomes clear that what Special Agent Heidi was saying was that, the question posed by defense counsel was he free to leave before you executed the search warrant? And Special Agent Heidi truthfully answered no. On redirect, it was clarified, well, what would have happened if when you pulled him over, you would have said, we're executing this search warrant and we'd like you to talk to us, and he said no. They would have finished executing the search warrant and he would have been free to leave. There would have been no way to undergo this interview pursuant to the search warrant. And the FBI acknowledged that during the trial testimony.
Can we get to, unless my colleagues have more questions on this, I want to go to official act.
Yes, Your Honor.
I'm struggling with the definition of official act the district court gave, because promoting the enactment of legislation could mean anything. If Arroyo had a Facebook account or the Facebook account of his lobbying firm liked a pro sweepstakes legislation post by Weiss, that could be seen as promoting the enactment of legislation. I mean, what would that qualify as an official act? Where do we draw the line on promoting the enactment of legislation. As a corollary to that, I want you to tell me where the court got this language from, because that's not the language the government proposed with the jury instruction. Your jury instruction just talked about the enactment of legislation, not promoting. It seems to me the district court added the word promoting.
Your Honor, I'd be happy to address the official act definition that was given by the district court. So to answer the first part of your question first, there was no plain error with the district court's instruction, and it was an accurate statement of the law. If you look at this instruction, which we call in our brief instruction A, that explains the official act at issue, in connection with instruction B, the bribery instructions, that is where the nuance, as Your Honor is asking about, is fleshed out. If you look at instruction B, it does explain kind of where the line is. It says that a public official makes a decision or takes action on a question when he uses his official position to exert pressure or advise another official. It goes on to say all of the things that defendant wants it to say as he argues before this court. A public official does not make a decision or take action on a question, matter, cause, or proceeding if he does no more than set up a meeting, host an event, or call or talk to another public official. In the context of this case, Your Honor, there was no confusion here reading these two instructions together and with the evidence that was presented. In the spring of 2019, the defendant and Arroyo are doing everything that they can to get this legislation passed. This is very different than McDonnell, where the concern about official action comes from. In McDonnell, payments were made to the governor of Virginia, and he then hosts meetings and starts conversations to learn more about the drug that the people paying him the money are asking him to learn more about. Here, our public official, Arroyo, takes money from the defendant, and then he is going out and speaking at committee hearings. He is approaching the three sponsors of the bill, all of whom testified at trial, Munoz, Rita, and Link, and aggressively encouraging them to include this in the legislation. Also importantly, at the time, I know promoting the enactment of sounds a little vague on its face, but at the time this is all happening, this legislation is pending in May of 2019 before the Illinois General Assembly. It ultimately dies. They did not succeed. But then when they pick this up again in August with the bribes of Senator Link trying to buy his official action, they're considering a trailer bill to try to sweep this legislation back in. So it is very much on the table as something that could have been changed by the actions that defendant was taking. Your Honor, respectfully, I do think that the government promotes the promoting, and the reason that I think that is because I don't have our initial proposal in front of me, but I do have our indictment, and promoting the enactment of legislation is in the speaking indictment. So whether it was proposed by the government or by the district court, I believe that is where that language initially comes from the indictment in this case.
But we don't have a case. The government can't point us to a case that defines promoting the enactment of legislation as an official act.
No, Your Honor. We cannot point you to a case that used that specific definition of official act. The pattern calls for us to describe the act at issue, and so that is what the parties were doing here. It's also important to note, Your Honor, that the defendant never proposed an alternate definition of official act. Throughout the two written filings of the jury instructions and the numerous jury instructions conferences that we had before the district court, they never proposed another definition of official act, and the pattern calls upon us to do that.
I know that the government's argument is that Weiss forfeited any objections to the jury instructions. He does claim that he objected to the inclusion of that sentence in R302. But the written objections there don't include an objection to that sentence. And separately, of course, during the 2 jury instructions, as you mentioned, the court asked repeatedly if there were any other issues with the jury instructions, and there was silence about the inclusion of that sentence. So any review that we would have would be, as you noted, for plain error.
That's correct. That's correct, Your Honor, and I believe that defendant in their brief concedes that plain error review applies here, or at least seems to concede that. I would also note that the waiver here is significant because the objections that defendant did raise in R302, that they wanted all 3 verbs included in the first section of instruction A, and the nuances that they wanted in instruction B, that all got in. They got everything they asked for here. So had they raised this below, perhaps it would have turned out differently, but they did not.
And how do you explain the language, the fact that the jury instruction at issue says agreed in part below it?
It says agreed in part because the defendant did not propose anything for the second bracketed sentence, and so they were not agreeing to our proposal, but they also did not propose an alternative. So we listed it as not agreed entirely.
So are you saying they both did not agree and also did not object?
I'm saying, Your Honor, at the time of the filing in May, where we said it was agreed in part, they were at least reserving at that time the ability to propose a second sentence. They were not agreeing with our second sentence at that time. I will concede that. That was far from the end of the discussion on jury instructions, and there were many opportunities after that for defendant to raise objections. They did raise other objections, but they never returned to this one.
And that not agreeing in May was not enough to preserve the issue?
Our argument is that it was not enough to preserve the issue. When the district court spent hours, and on the docket, this court can see, every updated red line draft is on the docket. The district court went through many attempts to capture everyone's opinions on this, and gave the opportunities to make a supplemental filing on the last day of trial, which defendant did. And so in the context of all that, we would say that earlier objection was not enough. Your Honors, if there aren't any other questions for me, we would urge this court to affirm the judgment.
I do have another question.
Yes, Your Honor.
What's your best evidence? I'm moving to the co-conspirator statements issue. What's your best evidence that Arroyo's offer to bribe Link would have been foreseeable to Weiss before that August 2nd meeting between Arroyo and Link?
Our best argument that the two were working together and that defendant would have foreseen Arroyo's outreach to Link is that defendant had been paying Arroyo for almost a year at that point. The payment started in November of 2018. So that is our evidence that they were working together. The defendant accompanied him to that meeting with Senator Link, and defendant was an active participant in that meeting up until the point that Link and Arroyo peeled off to have the what's in it for me discussion. Weiss presented his position on sweepstakes legislation to Senator Link, in the restaurant before the other two went outside. And then certainly there is evidence afterwards that...
My question was before the August 2nd meeting. You're taking me to the moment he's driving he's at the meeting, but before that.
Your Honor, we do not have any additional evidence of discussions between the two men specific to the attempt to bribe Senator Link. Mr. Arroyo did not cooperate. Mr. Weiss did not interview truthfully with law enforcement. So we have nothing else on what was in their head beyond the fact that Weiss was paying him for almost a year before.
Mm-hmm.
Thank you, Your Honors. We urge you to affirm the judgment and sentence of the district court.
Okay. All right, thank you, Ms. O'Neill. Mr. Usarovich, we welcome you back to the podium. We'll give you 3 minutes.
Thank you. Thank you to the court. With regard to Santiago, since we just finished that issue, there was no conspiracy in the legal sense formed between Mr. Link and Arroyo because Link was an agent at the time. So there can't be a conspiracy between one individual and an undercover agent. Hence, Arroyo's statement to Link before he spoke with Weiss, it wasn't admissible it was not admissible unless there was a conspiracy, which the court asked, to bribe Link that had already existed between Link and Weiss. Arroyo and Weiss. So no evidence has been presented to that fact. Indeed, you couldn't even find that because Mr. Weiss and Mr. Arroyo were not aware of the undercover operation. Indeed, they had a conversation that concluded, and then at the direction of the FBI, Mr. Link invited Mr. Arroyo outside of the presence of Weiss and pitched that idea of a bribe. So all the evidence shows that Mr. Link was told by the FBI at the last moment to make that nudge, is what came out in trial. So Mr. Weiss was not present for that conversation. And that's the same facts in Matac, where the woman spoke with an undercover officer, and the court found there couldn't have been conspiracy at that time. She made a prospective statement about delivering the drugs to the officer, just like Arroyo made a prospective statement about, let's talk in the future, we'll figure out the numbers and we'll get this going, and I only want to talk between the two of us, right? And later, when Mr. Weiss, so it's identical same facts, that those cannot be admitted because Mr. Weiss was not there and there was no conspiracy at the time between Mr. Weiss and Arroyo to bribe Link.
How do we factor in what the government pointed to, which was the information that Arroyo gave Weiss from Link that Weiss could not have obtained any other way, and the money that Weiss paid to both Link and Arroyo, and maintain that the district court abused its discretion by admitting Arroyo's statements that were made outside of Weiss's presence to Link.
Well, the money and everything, that's after the fact. And that's just like Macamedi's. The other conversations after that first one were admitted. And that we're not disputing that issue. We're only arguing that the main conversation shouldn't have been admitted because there was no conspiracy between Link and Arroyo, and there's no evidence to show that Link and Arroyo traveled there with a conspiracy to bribe. Arroyo and Weiss traveled to the restaurant with the idea of bribing Link or having a conspiracy at that time. There's no evidence of that, and the government said they don't have any evidence other than that. And the payments to Mr. Arroyo are not clear. He started supporting sweepstakes legislation in 2016 before the payments even occurred in 2018. With one thing I just wanted to address briefly, if I may, the Supreme Court was clear in McDonald that it's up to the jury under the facts of the case to determine whether the public official agreed to perform an official act at the time of the alleged quid pro quo. And the McDonald court clearly considered it's in the province of the jury to determine what constitutes an official act. So here, the district court did not merely provide an example of conduct that would constitute an official act as part of its explanation, but it told the jury that the conduct at issue would constitute an official act, such as promoting sweepstakes legislation. And it is so vague that it crosses over to McDonald, which says you can make phone calls, you can make meetings, you can talk to other people. So here, if someone was to act under the exceptions in McDonald's in relation to sweepstakes by talking to someone about sweepstakes, setting up a meeting about sweepstakes, taking a phone call about sweepstakes, they would then commit innocent conduct, which was criminalized by the jury instruction, not necessarily by the court.
Then help me with this, please. Jury instructions, of course, are reviewed as a whole. And the latter part of the jury instructions here included a long list of things that were not official acts. So within context, wouldn't it be clear that promoting legislation in the jury instructions would mean pressuring, coaxing, cajoling, lobbying, arm twisting other legislators at other legislators, which the district court said are core legislative functions. And, these definitions didn't direct the verdict for the jury. It was still up to them, to decide whether Weiss gave bribes in exchange for the promotion of gaming legislation.
Well, even though there were explanations, or otherwise, if you combine the instructions together, it might be a little bit clearer and less ambiguous than just looking at that one. That doesn't really matter because it's the jury that has to determine what constitutes the official act. You can give all those instructions. That was a secondary argument saying that it's confusing. But the primary argument is you can't define the official act under McDonald and under Lindbergh, which we cited, which was the Fourth Circuit. It's up to the jury to decide what the official act is. The rest of the stuff you're allowed to define, but the official act cannot be defined. But you can give that McDonald instruction saying these are not official acts. With that, I don't have much left for the court.
Thank you.
All right.
Thank you.
We thank both parties for your presentation today. We will take the case under advisement. We are going to take a 10-minute recess.
we resume with the third case of the morning, which is appeal number 23-1397, Small versus Woods, and we welcome Ms. Welch to the podium.
Thank you, Your Honor. Good morning, and may it please the court. Sarah Welch for the appellant, Dante Small. Mr. Small presses a single claim of ineffective assistance of counsel. He argues that he rejected a favorable plea offer because his attorney failed to correctly advise him of the 40-year mandatory minimum sentence he risked and ultimately received after going to trial. That single claim has two possible remedies at this stage. First, the existing record already supports one remedy, requiring the state to release Mr. Small or reoffer the already documented 20-year plea offer. Second, the other remedy is a remand for an evidentiary hearing to allow Mr. Small for the first time to submit evidence in support of his allegations, including that there was an earlier 10-year offer. Section 2254 does not bar either remedy. The state court screened Mr. Small's claim as frivolous because it concluded that the key transcript passage was irreconcilable with Mr. Small's allegations. That was an unreasonable determination of the facts because the claim and the transcript are readily reconcilable. In fact, the transcript passage documents the 20-year offer and reflects Mr. Small's attorney's incorrect understanding of Mr. Small's sentencing exposure.
Now, Small's habeas petition argued that he would have accepted the state's offer for a 10-year deal, but it doesn't make mention of a 20-year deal. If we find that it was an unreasonable determination of the facts, that Small understood his sentencing exposure to be 40 years, does the fact that Small only referenced a 10-year deal but not a 20-year deal preclude relief?
No, Your Honor. The state's lead argument is procedural default, so I'm certainly happy to start there. Mr. Small has always asked, including in his initial pro se filing in the post-conviction relief proceedings, for relief on the existing record or an evidentiary hearing to allow him to continue developing his claims. The existing record documents that 20-year offer. In addition, the question that the court faces when it comes to procedural default is whether the petitioner is asserting the same claims that he fairly presented to the state court. And the court defines the same claims as whether they involve the same operative facts and the same controlling law. Every court to look at this claim has recognized that April 27th transcript passage is the key transcript passage to consider this claim. So that's the same operative facts have always been involved. And the same controlling law has always been involved. This has always been a claim of ineffective assistance of counsel for failure to correctly advise Mr. Small of that mandatory minimum sentence. So we do think that Mr. Small has been constantly pressing the same claim and even seeking exactly the same forms of relief on that claim throughout his proceedings, even when he was pro se before the state post-conviction courts.
Before you move on, how much of his sentence has Mr. Small served to date?
I believe it's been about 14 years.
Thank you.
The state also presses a forfeiture argument in connection with its issue preservation arguments. And as to forfeiture, the court has acknowledged that litigants have the right to refine their claims on appeal to continue developing them. Before the district court on page ID 110 in Mr. Small's habeas petition, he did request again relief on the existing record or relief via an evidentiary hearing to allow him to, for the first time, present evidence in support of his claims. So again, Mr. Small has developed those claims further with the assistance of counsel once the court appointed counsel to represent Mr. Small, but that's well within the norm for what a pro se litigant is permitted to do in refining his arguments on appeal. I'd like to turn to deference to the state court's findings under section 2254D, as that's cross-cutting between both remedies that we request and was really the basis for the district court's resolution of Mr. Small's claim. The state court rejected Mr. Small's claim based on its unreasonable determination of the facts in concluding that the key transcript passage was just irreconcilable with Mr. Small's allegations. In the state court's Language on page A75 of our appendix, the state court said that the transcript completely contradicted Mr. Small's claims. In other words, it just logically couldn't be squared with Mr. Small's allegations. That's not the case. At absolute minimum, the transcript doesn't rebut Mr. Small's allegation that he was never advised that he faced mandatory consecutive sentences for a true mandatory minimum that he ultimately received 40 years as opposed to the 20 years that the attorneys and the 21 years that the court discussed on that transcript. And we don't take the state to argue otherwise on that. They instead argue that that either Mr. Small didn't really care about the possibility of consecutive sentencing, or that there wasn't really a mandatory consecutive sentence requirement. As to the first argument, the record just rebuts that. We've cited a number of places where Mr. Small raised the issue of mandatory consecutive sentencing. And just from a common sense perspective, it was a difference of 20 years, of a requirement of 20 years, and that would of course matter to anybody. And as to the second argument that the consecutive sentences weren't really mandatory, the state's argument on that point is that they were mandatory only if the state trial judge made a finding that Mr. Small had inflicted severe bodily injury on his victim. Even if that finding... Yes.
Let me ask you this. The state court focused its attention on the colloquy. And in that colloquy, the prosecutor indicated that an offer of 20 years had been given on the primary charge. A few minutes later, the prosecutor stated, that's the minimum, okay? Is there any way that Small could have known that he faced a minimum 20-year sentence on each attempted murder charge due to the prosecutor noting on the primary charge?
My reading of the transcript, Your Honor, is that the comment about the primary charge was reflecting that the 20-year offer was a charge bargain, so the state would dismiss the remaining charges, there were 2 other charges, and would accept Mr. Small's plea of guilty on only the primary charge. So I think that's what that comment was about. I don't think that the transcript reflects that. Apologize.
I'm very confused by that whole colloquy. I have to say that straight out. I mean, we'll talk to Mr. Wood's attorney, but.
Sure, Your Honor. I do think that the colloquy coming up specifically in the context of Curry admonishments, the court's question of whether Curry admonishments were necessary also reflects Mr. Small's attorney's lack of understanding of the total sentencing exposure that Mr. Small faced, because Curry admonishments speak to the entire sentencing exposure of a defendant. Those were the facts of Curry itself, where the defendant faced mandatory consecutive sentences if he was convicted of multiple counts. And Curry admonishments, the court found in Curry that defendant had received ineffective assistance of counsel because he hadn't been instructed told about that possibility of mandatory consecutive sentencing. And so Curry admonishments arose to prevent that in the future by making sure that a defendant is told on the record of the total possible mandatory sentence that he could receive if everything goes against him at trial. And so that context, we think, particularly cuts in favor of Mr. Small's arguments and against the state court's findings. I'll turn briefly to Mr. Small's argument for an evidentiary hearing to allow him to develop the basis for his arguments. Section 2254E2 permits evidentiary hearings in state habeas proceedings if a petitioner has diligently pursued his claims and his request for an evidentiary hearing throughout the state court proceedings. This court also applies a pre-2254 standard, and we've briefed that in our opening brief, and the state hasn't made any argument in its brief that Mr. Small doesn't meet that standard, so I'll address only Section 2254 standard. Mr. Small has been diligently asking for an evidentiary hearing since he first raised this claim in post-conviction proceedings. That first request is on page A99 of our appendix. That's been enough in a number of this court's cases, for example, Davis, Jones, Lee, Avila, and Ward. And the state rests on the point that Mr. Small didn't attach affidavits of potential witnesses to his post-conviction review petition. He did attach his own affidavit, and he would be presenting his own testimony, most likely, in an evidentiary hearing. So he did provide verification, as his attorneys argued, to the state courts. The state courts never found that that was procedurally deficient, and instead just noted the argument and then proceeded to resolve Mr. Small's arguments on the merits. And in addition, Illinois law requires either affidavits or an explanation of why affidavits aren't attached. Mr. Small had requested 2 extensions that the court didn't rule on prior to the deadline for filing his petition. In those extensions, he explained that he had affidavits to support his claims, but they had been taken from him by the prison when he was released from segregation, and he documented that by attaching a grievance to his post-conviction review petition.
Are we to take anything that in all the time since then he hasn't reproduced the affidavits?
There's never been an opportunity for him to produce those affidavits, so the court ruled on his petition without asking him to supplement or allowing him to supplement, just screened it out as frivolous. And then he was never able to present that on appeal, of course, because it wasn't part of the record. And then he couldn't attach it to his initial 2254 filing in the court below because the court would need to grant it evidentiary.
Is there anything in the record that tells us who these mystery affidavits were from?
I believe on page A98 of the appendix, he says that his attorney had consulted with him and his family. So that's likely what the affidavits would be about. And his habeas petition just contains these allegations about his attorney's advice being 6 to 30 years, the existence of the 10-year offer, and his attorney's failure to tell him about the mandatory consecutive sentencing exposure that he faced. If the court has any other questions, I'm happy to answer those, or I'm happy to reserve the remainder of my time for rebuttal.
All right, thank you, Ms. Welch. All right, we will now hear from Mr. Malamuth, and please correct my pronunciation when you approach.
Good morning, Your Honors. May it please the Court. Assistant Attorney General Eldad Malamuth on behalf of Respondent. This Court should affirm the denial of habeas relief and the denial of an evidentiary hearing. And the reason for both is that Section 2254D2 prevents either from occurring. And that is because the State Appellate Court did not make an unreasonable factual determination in this case. Now,
may I stop you because what sentence in the colloquy between Small's counsel, the prosecutor, and the court about the need for a Curry admonishment advised Mr. Small that he could face consecutive sentences? Did the colloquy ever mention the words consecutive or concurrent?
No, Your Honor. So the colloquy, the factual determinations relevant from the colloquy are twofold. One, that that there was no 10-year plea offer made. And that's actually the key allegation in this case that has been relied on by the state trial court and the state appellate court and the district court. The second is petitioner's claim that he was unaware that petitioner's claim that he believed that he faced a sentence as low as 6 years under the primary charge. And those two things are distinctly contradicted by the colloquy, and that is what was relied on by the state appellate court, the state trial court, and the district court. And the colloquy clearly contradicts those factual assertions made by petitioner. So petitioner asserted.
How do they do that? It's such a confusing colloquy.
Well, Your Honor, the colloquy proceeds like this. The parties, the judge asks if the Curry admonishments are necessary. So that is to say whether an offer was made below the minimum that the court needs to admonish the petitioner about, or the defendant at that point, before proceeding to trial. Now, everyone agrees that the minimum sentence on the primary charge is 20 years. Everyone agrees that no offer was made below the minimum. Now, just as a matter of logic, if there's no offer made below the minimum, there's no offer made below 20. So there's no 10-year offer made. So that's the issue of the 10-year offer. Second, petitioner had asserted that he was unaware that the minimum sentence was not 6 years. Well, in this colloquy, everyone agrees, with petitioner present, that the minimum is 20 years. And so if the petitioner is aware at this point of the minimum sentence not being 6 years, this contradicts his assertion that he was unaware of that. And petitioner, in fact, really concedes this. His argument is more that he might have been unaware at some previous points, and there might be some other explanation of why he didn't object to the 20-year minimum that was put forward and agreed to by everyone. But that does not change the fact that it conflicts with his knowledge, and that the state courts were reasonable in finding that to be the case. And that is particularly true because the petitioner, it was his burden to set forth in the petition or attach affidavits or record evidence which would support his claims.
Look, the prosecutor says, I think the minimum was 20. We did make an offer of 20. And his defense counsel says, you did? I mean, he doesn't even seem to know that.
Well, they agree, Your Honor, that the 20 years is not below the minimum. And if you look, as the colloquy continues, defense counsel specifically states, this is on page A63, so appendix 63, as the colloquy continues, they are discussing, so the offer was 20, yes, on the primary charge, exactly, okay, and the defense counsel says, which has been rejected.
Okay, so here's the thing. The poor guy is standing there, right? Nobody says to him, do you know what's going on here? First, his attorney says, you did? He doesn't know that 20 years been offered. And then he says, later on, the defense counsel says, which has been rejected. I mean, if this isn't confusing, or maybe I'm just a confused person. I'm terribly confused by all of this. I can't even imagine what Mr. Small must have been thinking, what's going on here? And no one says, Mr. Small, do you know what happened here? Help me, someone.
Well, Your Honor,
just
as an aside, Mr. Small was consistently vocal during these hearings. He, for instance, specifically asked to speak against the advice of counsel and asked for a speedy trial, even though his counsel had told him not to. I mean, complaining about the counsel at various points. So there's no particular reason to think that, Mr. Small wouldn't have voiced disputes if he had one with the colloquy. But in any event, the key here is
the state court is relying exclusively on the colloquy related to the need for a curry admonishment, but nothing in the exchange notifies the defendant that his sentences could run consecutively, and that in reality he is facing a minimum of 40 years.
Well, Your Honor, the colloquy doesn't reflect whether petitioner's counsel informed him that the sentences could run consecutively or not. The colloquy doesn't address the issue of the potential of consecutive sentences. And as a legal matter, that was right. I mean, consecutive sentences weren't mandatory. Now, if he had raised a claim, and to the extent he argues that he hadn't been told that his sentences could run consecutively, that particular factual allegation is not contradicted by this colloquy. But the question is whether the factual determination that the state courts made was unreasonable, whether it was an extreme malfunction of the judicial system for them to base their determination on this colloquy.
That really depends on how you're asking the question. If we find that he consistently has pressed the issue that he was misinformed or underinformed about his sentencing exposure, at that level of abstraction, if we find that, do you agree that the colloquy we have been discussing does not inform him of his sentencing exposure in terms of the fact that he could get consecutive sentences? The fact that the minimum is actually 40.
Well,
in other words, does your argument only work if you ask us to construe his argument in the very way the state court did, which is to be one specifically about, I thought the min was 6. I thought there was a 10-year plea deal, as opposed to a broader question of, I have been misinformed. I am trying to tell the courts I have been misinformed.
So, Your Honor, to step back for a second, and the state court was faced with petitioner's claim. Petitioner claimed, I turned down a 10-year plea offer, and I did so because I was unaware. I believed that the minimum sentence was 6 years. And, by the way, also, I was never informed that my sentences might run consecutively, or had to run consecutively, as he phrased it. And the state court looked at this claim and said, the record before us contradicts your assertion that there's a 10-year plea offer. And, by the way, it also rejects your claim, it contradicts your claim that you weren't aware that the sentence was below, that you believe that you faced a minimum of a 6-year sentence. And based on those findings, we reject your claim. Now, petitioner has to come here under 2254 and say, that was unreasonable. No fair-minded jurist could reach that conclusion. And the avenue and petitioner even acknowledges that to get to the issue of whether or not the consecutive sentences might entitle him to relief, you have to find that the factual determinations that there was no 10-year plea, and that he wasn't aware that his minimum sentence was 20 years, have to be unreasonable. So they have to make those determinations. We have to say these factual determinations were unreasonable, and we have to do so before we can proceed in any other way in the case. And when Judge Rovner, you say that they was just basing on this colloquy, but once again, that's part of the problem is because petitioner did not provide any affidavits or any material evidence to suggest otherwise. Now, he raises this assertion that he did not have, that these affidavits had gone missing after he had gone to segregation in prison. But first of all, even the documents he provided indicate that he had signed a document stating that he had been returned, that he had received all his materials back. But in any event, he also had 3 months after he filed the petition, approximately 3 months, to supplement the petition with affidavits before the court ruled. He had weeks after he returned from this incident before he mailed out his petition. He also had the opportunity to explain who these affidavits would be from, what they would say. He didn't do any of those things. And under Illinois law, he was required to do so. And just a quick point about that, petitioner asserts that somehow the state appellate court disclaimed this requirement as a basis for its decision, but that's not right. So the Post-Conviction Hearing Act in Illinois has two distinct requirements. One is that under 122-1 of the Act, there's verification. This is a pleading requirement that all the allegations are brought, truthfully and in good faith, and a separate requirement that the petitioner attach affidavits that show that his allegations can be corroborated independently. And what the state appellate court said, and petitioner had just provided one affidavit, and the question was, well, whether this could count as both. And the state appellate court said, we're going to assume without deciding that just sort of as a minimum pleading requirement, this is sufficient. But then it immediately goes on to say, however, under 122-2, petitioner has provided no supporting records on which his allegations could be corroborated. And so all that we're left is with this colloquy. And again, so the state court has turned down a 10-year, the claim that there's been this 10-year plea offer based on these two factual determinations. The claim that he would rejected a 20-year offer has never been made. He never asserted that he would accept a 20-year offer. And so that operative fact was not before the state appellate court. And so the state appellate court, so that's defaulted and can't form a basis for habeas relief.
If we disagree with you and we determine there is no procedural bar or epi bar to us reaching Small's claims, do you agree an evidentiary hearing is appropriate as opposed to the outright relief that Mr. Small is requesting?
Well, no, because it's still 2254 D2 still would bar the evidentiary hearing because there was no unreasonable determination made on the 10-year plea offer, and that's the basis of the denial of relief in the state court. And also because under 2254 E2, petitioner was not diligent. Petitioner claims that there are all these cases in which just requesting an evidentiary hearing is sufficient, but that's not true. So very quickly, in Lee, there were multiple affidavits provided to the court, and in Davis versus Lambert, there were I think it was 7, but there were several descriptions of what witnesses would testify to, who the witnesses would be, what they would testify to. Petitioner did not make that showing, and so he wasn't diligent in developing the factual record in state court. So I see my time is up. Unless the court has any further questions, we would ask this court to affirm the judgment of the district court.
Okay, thank you, Mr. Mahmoud. All right, Ms. Welch, we welcome you back for your rebuttal time.
Thank you, Your Honor. Just a couple of points in response. I'd like to begin with what I take to be the warden's consistent acknowledgement that, as Mr. Malamud said just now, That particular allegation, referring to the fact that the colloquy doesn't discuss consecutive sentences, isn't contradicted by this colloquy. And because the state court's rejection of Mr. Small's claim as frivolous relied on the idea that the colloquy did contradict that allegation in Mr. Small's petition, I don't understand how there could be Section 2254 D1 deference to that conceitedly unreasonable determination of the facts, that there was a contradiction between the colloquy and Mr. Small's allegation that he was just never told of the exposure that he faced to mandatory consecutive sentences. I'd also like to address Mr. Small's diligence. First, to Mr. Malamud's discussion of whether the state court relied on the lack of affidavits from other witnesses attached to Mr. Small's post-conviction petition. The state court did disclaim that as a basis for its decision on pages 14 and 15 of its decision. It said, assuming without deciding that Mr. Small's 122.1 affidavit, which he did attach, was sufficient, it rejected the claim as completely contradicted by the record. As to Davis, which strongly supports our argument that Mr. Small was diligent because the petitioner didn't attach affidavits there, it's true that Mr. Davis did describe in more detail than Mr. Small what the witnesses would have said. That was necessary for his claim because his ineffective assistance claim in Davis was that counsel was deficient for not having called those witnesses. So it would have been impossible for him to make that claim without describing what the witnesses that his attorney didn't present would have said, and that was necessary for his deficient performance argument. Finally, just to go back to Mr. Small's allegation that there was a 10-year offer, the warden continues to argue that the record contradicts the idea that a 10-year offer was ever made. The fact that there was a discussion of the 20-year offer, we know there was a 20-year offer, doesn't mean that there was never an earlier offer. It's certainly possible that Mr. Small could present evidence that would establish that there was an earlier 10-year offer. And supporting the idea that that is consistent with the plea colloquy, the record reflects that there was a different prosecutor during that colloquy versus in previous discussions with Mr. Small on the record. And Mr. Small's attorney, as Judge Rovner noted, wasn't aware that there had been any offers in the case, so he was not going to be able to say on the record exactly what the history of plea negotiations had been. So we'd ask the court to rule for Mr. Small. Thank you.
Well, thank you, Ms. Welch. And we see that you were appointed to represent Mr. Small. You have our thanks and the thanks of the court for accepting the court appointment. We will take the case under advisement. And we move now to the fourth case of the morning. That case is two appeal numbers 24-1171 and 24-1197, Orr versus Schicker. And once everyone is settled, we will welcome Mr. Heller to the podium.
Thank you, Your Honors. My name is Kent Heller, and I represent about 2,000 prisoners in this case. I would like to reserve 3 minutes for rebuttal. Imagine, if you will, that you're a reasonable person, and you are seeing your doctor, and he says, "I've got bad news. You have hepatitis C. It's a fatal disease. It will kill you. We don't know how long it'll take to kill you, but sooner or later, if you don't do something, it probably will. It causes cirrhosis of the liver, can lead to liver cancer. It can require a liver transplant. And oh, by the way, there's a cure." That cure, however, is much different than the old cure when this case started, where you had to take pegylated interferon. This cure involves taking 1 pill a day for 84 days, 7 weeks. And it's 95% effective. But it costs $12,000, which is about what it costs to take a family of 4 to Disney World. But the state won't pay for it. Every medical expert who has testified in this case agrees that the standard of care is to treat people with hepatitis C. The World Health Organization says you treat people with hepatitis C. The National...
Mr. Angermeyer, forgive me for interrupting, and I hope you'll add this time that I'm speaking to his time, Judge Jackson Akumi. Is Mr. Huang present?
I don't...
I'm Mr. Angermeyer on the next case.
He's supposed to be remote.
We're on Orvi Schicker. Case number 4 and 6 have been flipped.
I'm sorry. I see. Thank you. Yeah, I see.
And so we have 2 in-person counsel for this argument.
I'm sorry.
No problem.
Let me ask you this, though. Even if we found that the lawsuit was brought against the defendants in their individual capacity, how could the complaint adequately apprise the defendants of the claim against them when it does not identify the specific policy that they adopted and which was allegedly medically insupportable?
Well, first of all, there have been multiple policies throughout the course of this case. Secondly, there's a companion case, Lippert versus Department of Corrections and a number of those officials. And this case had this issue before it earlier in this case. And when it came to injunctive relief and treatment, Judge Baker went for several years trying to, quote, close the class. That is, get treatment for these people so that there wouldn't be more people coming in. As long as they're not treated, everybody that gets hepatitis C and doesn't get treated loses and has damages. One of the things I didn't get to in my list of problems is that every year hepatitis C goes untreated, they lose a third of a year of life expectancy. So their life expectancy is shortened every year. And at the injunctive hearing, which is what I was referring to, the medical experts testified that in public health cases, the value of a year of life is considered to be $50,000, and if the treatment costs less than that, in other words, a third of a year's life would be worth somewhere around $16,000, then from a public health standpoint, it makes sense to treat it, but they didn't. There isn't any question in this case, but that the policy that this case is directed to is the failure to treat people with hepatitis C. Whether they call it a prioritization, whether they call it a rationing of the drugs, or what they really call it, and the truth of the matter is, they just don't want to spend the money. Now, I admit, 2,000 people at $12,000 apiece, that's about $24 million. In 22 and 23, the state of Illinois spent $2.64 billion on illegal immigrants, and yet they won't treat these human beings who have a fatal disease that they can cure by giving them 1 pill a day for 7 weeks. And that's really what this case is all about. There has never been any defense raised in this case that it's about anything other than money. It's cheaper to, quote, watch it and see. The problem is, and again, the testimony is in the record, nobody knows when tomorrow you're going to go from a level 1 to a level 3 or a 4 and need a liver replacement. There's no way to predict. We're all different. And the only way to treat the situation is to give these people the medication, the antiviral drugs. In the Lippert case, and I suspect that it's possible that some of the plaintiffs in this case would have been, this case was filed in 2008. So they could have been out of the Department of Corrections by 2008 and thus not have been Lippert class plaintiffs. But if there aren't very many of those. So literally everybody in this case is also a class member in the Lippert case.
Do you see at all some of the confusion the district court felt it was confronted with here?
Well,
for example, your complaint asserts that the court has jurisdiction over the plaintiff's request for injunctive and declaratory relief.
declaratory and injunctive relief pursuant to it, and it names the statute. But do the plaintiffs in the complaint seek injunctive and declaratory relief?
Well, they did, until this court said, if you want injunctive relief, you've got to get it in the Lippert case, because you're all members of the Lippert case, which is why we filed the motion to consolidate this with Lippert. And you have to look at the monitor's report in the Lippert case, where the monitor said there is no justification, legal, medical, or moral, to not treat these people.
So should you have revised the complaint then?
I was not going to ignore the order of this court saying I couldn't get injunctive relief and then turn around and say, well, I know you told me I can't, but I'm going to ask for it anyway. After the first remand of this case, what the court said was, if you want injunctive relief, get it in Lippert, and oh, by the way, you can continue to pursue monetary damages in this case. We had direction from this court as to where to go and how to proceed. And so I don't think it is confusing when we had the Roe case, which was, as Judge Baker pointed out continuously, our roadmap, because it's exactly the same circumstances we have here. And then secondly, we had the order of this court on the appellate decision.
Okay, so in other words, at this point, all we have to, your argument would be that at this point, all we have to decide is that the claims by their nature present claims in their individual capacity.
Yes, ma'am.
Right?
And that if in fact they do, and if we need to add that word, as opposed to the district court's finding that these plaintiffs have no claim, that in fact they do. That people who have hepatitis C and who are in prison have a serious medical condition, and the failure to treat that constitutes deliberate indifference. It can't be anything else. They've been fighting this for 16 years. They can't be doing it unintentionally or mistakenly.
Now, you stated in your brief that the court should not have dismissed the deceased plaintiffs because you filed a motion to substitute the public administrator for the deceased plaintiffs prior to the dismissal. When was that motion filed, and what happened with it?
Well, I can't give you an exact date as I stand here, but I would estimate it was filed 10 or 11 years ago. The court's comment was, we can take care of that. That's a direct quote. And nothing ever did happen. That motion is still pending. It's never been ruled on. With that, I would like to reserve the rest of my time for rebuttal.
Very well.
Thank you.
Thank you, Mr. Heller and Ms. Shrove. You could correct my pronunciation, please, when you arrive.
Good morning, and may it please the court. My name is Alexandrina Shrove, Assistant Attorney General, on behalf of defendants appellees Dr. Schicker, Meeks, Bowman, and the Illinois Department of Corrections. Neither of plaintiffs' operative complaints in this case identified in which capacity defendants were being sued, nor did they provide enough factual allegations to state an individual capacity claim against the defendants, despite multiple opportunities for them to do so. Accordingly, this court should affirm the dismissal of those complaints by the district court for two primary reasons. First, despite not labeling them as such, plaintiffs' claims were brought against defendants in their official capacity and sought damages, a type of relief that's not allowed in federal court. And two, even if plaintiffs' claims were against defendants in their individual capacity, they still failed to state a claim upon which relief could be granted.
You know, you state, I'm going to take you here. You state in your brief that because the plaintiff's allegations focused on the creation and implementation of a department policy, the district court properly concluded that the plaintiffs brought their claims against the defendants in their official capacity.
Correct.
I need to know how you can reconcile that argument with our decision in Roe versus Elia, in which we upheld a damages award against Illinois Department of Correction medical director in his individual capacity based on a categorical treatment policy by him that was violative of the Eighth Amendment. I see very little difference in your case, in this case, and in Elia.
Your Honor, there's two primary distinctions between this case and the Roe case. First and foremost, Roe is distinguishable because there was never a question that the medical director was being sued both in his individual capacity and also in his official capacity, which we don't have that clarification here. And second, the complaint in Roe contained many of the facts.
Let me answer that first statement. The pursuit of compensatory and punitive damages in the claims should have apprised the defense that the claims were against them in their individual capacity, because such damages are available only in a suit in their individual capacity. So what is the second point you wanted to make?
Your Honor, the second point is that the complaint in Roe contained many of the factual allegations that are missing from this complaint. The Roe complaint included specific allegations about the 4 named plaintiffs, including information about their Hep C diagnoses and how they requested and were denied treatment under the existing treatment policy at that time. The complaint also contained allegations about the Hep C treatment policy itself, which prohibited treatment for any Hep C inmates that had less than 18 months left on their sentence. And it detailed how the plaintiffs were individually injured by those treatment policies. But here, we don't have any of those factual allegations contained within the complaints. They don't identify when the medical directors were the directors. They don't have any information about the policies themselves. And most importantly, we don't have any information about the plaintiffs themselves. We have no information about any of their Hep C diagnoses, any of the treatment plans, any of the treatments that they've received so far, nor do we have any information about the injuries that they've allegedly received as a result of these treatment policies. So we're missing all of the factual allegations that were present in the Roe case. And so that's what makes Roe incredibly distinguishable from this case here.
Look, as in Elia, the claims here can be brought against the defendants in their individual capacity because they're responsible. The defendants are responsible for the initiation of the policy, which purportedly violates the Eighth Amendment by categorically excluding inmates from medical treatment based on medically insupportable reasons. Nothing in the nature of the claim here renders it limited to the defendant's official capacity as far as I can see. And the pursuit of the compensatory and punitive damages, as I noted, should have apprised the defendants of the claims were against them in their individual capacity. So if we start there, then we've got a problem here.
Well, Your Honor, I would first note that when we look to the actual allegations themselves, it's clear why the district court was correct in assuming that these allegations were against the defendants in their official capacities. The plaintiffs, despite multiple opportunities to amend their complaints to do so, failed to ever identify in which capacity these defendants were being sued. And under this court's precedent in Hill versus Shalander, when a complaint challenges a policy or custom, the court will presume that those allegations are against the defendants in their official capacity. And so here, because of the fact that plaintiffs have failed to identify which capacity defendants were being sued in, and when we look to the actual allegations themselves, it's clear that they're attacking this department-wide treatment policy. It was correct for the district court to presume that these claims were being brought against defendants in their official capacities. And because they were being brought in their official capacities and sought, as you mentioned, compensatory damages, it was proper for the district court to dismiss both of these complaints because that type of relief is simply not allowed for official capacity claims in federal court under Section 1983.
Doesn't the complaint allege that the defendant medical directors adopted a policy that failed to treat hepatitis C for all inmates who had, certain fibrosis levels, and that none of the plaintiffs received appropriate medical care for the hepatitis C, and that the reason for the refusal of treatment was based not on any medical basis, but solely on cost? Doesn't it?
Your Honor, those are what the general allegations are, but I would point out for the court that this is not a class action complaint. We don't have a certified class here. And so what we're missing is specifically relating to the individual plaintiffs is any information about their individual hep C diagnoses, any of the treatment that they've attempted to receive and or been denied under these policies. And this information is incredibly important because when we look to whether or not defendants were deliberately indifferent to their medical needs, plaintiffs have acknowledged how drastically the hep C treatments have changed over time. And so the policies themselves will have changed over time. And we need to know the dates of when these policies were implemented, the dates of when the medical directors were implementing these policies, and also at what level the hep C diagnoses were for any of these individual plaintiffs to determine whether or not they've stated a claim here. All of those factual allegations are missing from this complaint. And I would also point out, Your Honors, that despite plaintiffs' suggestion that the dismissal was incorrect and that the complaints can be readily amended, they have failed to ever ask for the complaints to be amended. They did not include a request to amend their complaints as part of the motion to dismiss before the district court. They didn't file a motion after the fact, nor did the plaintiffs in either case file a motion for reconsideration of the district court's decision if they believed that the district court had misconstrued their allegations and misconstrued what capacity the defendants were being sued in here. They haven't asked for any of that. So the district court cannot be said.
The court found that any amendment would be futile because they are precluded from seeking damage for the official capacity claims brought. But that decision regarding the futility of any amendment rests on the faulty, to my view, determination that the case was brought against the defendants in their official capacity. So, for me, as I sit here, the dismissal on that basis was improper.
I see that my time is up. May I have a brief moment to respond to your question, Your Honor?
Oh, I hope you do.
The issue here is that they didn't even ask for a motion or file a motion for reconsideration if the assumption was that the district court had misconstrued what capacity defendants were being sued in. That was the basis of the district court's decision that the claims were being brought against the defendants in their official capacities. And if that was incorrect, if the plaintiffs believed that that was an incorrect decision by the district court, they should have filed a motion to reconsider that and explained why that was incorrect.
You know, that's not actually a rule. That's what the appeal is for. They're here on appeal pressing the issue. That's sufficient.
Your Honor, I would just point out that they failed to either ask for an amendment or to file that motion for reconsideration. It's clear here that the defendants were sued based on the allegations themselves in their official capacity, and it was correct for the district court to dismiss the complaints under that basis alone.
All right, seeing no further questions, thank you, Ms. Schroe.
Thank you.
Mr. Heller, you had reserved a time. We could give you a full minute, please.
Thank you. May it please the court, 3 items. One, both in Roe and in this case, the issue of 11th Amendment immunity was raised a number of times. This is nothing new, and it was obviously clear that the individual counts seeking compensatory damages were directed at the defendants in their individual capacity. As to the issue of knowledge of what the complaint should have had in it, all of the things that defendant suggests should be in the complaint are in the possession of the defendants. They're the ones that did the examinations. They're the ones that have the records. They're the ones that made the policies. They're the ones that appointed these people for terms of office. But third, and more importantly, the posture of the case. Judge Baker had this case for 16 years. And at the point where this court said, we're not going to we overruled Judge Baker's certification of this case as a class. The district court was left with 2,000 individual plaintiffs. Can you imagine what the complaint's going to look like if we have the individual allegations of 2,000 plaintiffs as to what each one did in terms of treatment? Judge Baker and Judge Long had the plaintiffs and defendants. He statistically picked the top 100 people, and we analyzed those records and tried to come up with a plan that would compensate them based upon some type of modeling like you would have in a mass tort action or in a class action. And we analyzed those hundreds, and we submitted various plans to Judge Long, and the state said, not interested. Judge Baker died. Judge Darrow took over the case, and this was her first contact with the case. It isn't that we don't know these things or that we haven't shared them. We worked on them extensively, probably for over 2 years. So for her to suggest that they don't know is just absolutely wrong in terms of what really happened here. We asked the court to reverse the district court and to remand this case for further proceedings. Thank you very much.
Right. We thank both parties, and we will take the case under advisement. We will move to the 5th case of the morning, appeal number 24-1632, Yokash v. Colvin.
Good morning, Your Honors. May it please the court. My name is Vincent Angermeyer. I represent the appellate Lori Jean Yokash. I'd like to reserve 2 minutes for rebuttal. During the period in question prior to September 2017, Ms. Yokash was in significant pain caused by deteriorating discs in her cervical and lumbar spines, small fiber neuropathy in her lower extremity, and osteoarthritis in her left hip. The government's own testifying physician, Dr. Ghazi, testified that pain increased over this period of time until September 2017, when it became simply incapacitating and rendered Ms. Yokash incapable of performing any type of work, no matter how simple. The question of whether the prior state of affairs left her unable to perform complex work as well is addressed by only one opinion in the record, that from the psychologist, her treating psychologist, Dr. Matusiak. But it's important to note that during this period of time, even according to Dr. Ghazi, and even according to Dr. Manos, the consultative examiner that Dr. Ghazi relied on, Ms. Yokash in a work environment would have been going through cycles of aggravated pain followed by pain relief. She would be unable to hold a seated or standing position for more than 15 minutes without needing to change position, and then the government accepted that finding and added to it that each time she changed position, she would need 2 or 3 minutes to adjust. Dr. Matusiak's opinion that she was during this time unable to meet the mental demands of complex work, even though she could meet the mental demands of simple work, is uncontested in the record and backed by objective testing specifically designed towards evaluated individuals with chronic pain. Nonetheless, that opinion was rejected by the ALJ. Since this is an application from prior to May 2017, that rejection is governed by the treating source rule. It needed to find good reasons for not granting compelling weight to that opinion based on the supporting evidence and its consistency with the record. And if that was not found, it needed to proceed through the factors in 404.1527C and address each factor in a manner that's supported by substantial evidence and minimally articulates the judge's analysis. This court recognizes that while the ALJ's description of each factor, moving on. And here, ALJ Ginger's discussion of almost every factor shows that his failure to recognize that Ms. Yokash had been diagnosed with a pain disorder shows that he was simply not aware of Dr. Matuziak's reasoning, the objective evidence it was based on, his qualifications to assess that evidence, or even what he was treating Ms. Yokish for. The P3 index was evidence directly cited in Dr. Matuziak's opinion, and yet the name of that test goes unmentioned in the ALJ's decision, and so did the results. That simply does not minimally articulate how the ALJ evaluated the supportability of the opinion. Similarly, this failure to understand that there was a diagnosed pain disorder tainted his consistency analysis in 3 different ways. First of all, he does not acknowledge the objective medical imaging showing the deterioration in her general medical condition, even though in the DSM-4's definition of pain disorder with associated psychological factors in general medical condition, that is specifically cited as an associated medical finding. In fact, MRIs of the lumbar spine, which are present in the record, are specific examples of the kinds of supported findings, and yet they are not discussed as evidence consistent with Dr. Matuziak's opinion. Second, this misunderstanding of what she had been diagnosed with led to a flawed analysis of her treatment history. The ALJ claims that she received only conservative treatment for her mental health issues, basically talk therapy, and yet this is a pain disorder. It's caused by physically generated pain, and the record extensively documents her receiving painkillers, radiofrequency ablation, and injections for this issue. In a prior decision, ALJ Gendrew attempted to characterize that treatment regimen as conservative, but that was appealed, and the appeals council remanded saying, we don't really see the evidence that that's only conservative. That sounds pretty significant to us. And then he abandoned that. So I think it's now conceded that the treatment she received for pain relief was not conservative in nature. And I think that that shows that the ALJ's analysis of only anxiety and depression and not the pain disorder was a material error. Third, it also leads the ALJ to rely on mental status exams that his own testifying psychologist advised him are simply not useful in assessing whether higher level restrictions on mental functioning are present. They're good for evaluating whether basic skills have been compromised, but otherwise he refused to provide an opinion on complex work because neither those status exams nor anything else in the record really gave him anything to work with. And he did concede that the test performed by Dr. Matuziak would have been sufficient to inform a reasonable opinion on that. It's just that he wasn't going to offer an independent corroboration of that without access to the raw test scores. Unfortunately, the ALJ played doctor and relied on the exact kinds of evidence that his own medical expert warned him were just simply not adequate to rebut a finding of limitations on complex work tasks. And unfortunately, even as he overlooked or implicitly rejected and declined to share his reasons, that part of Dr. Rabin's testimony, he accredited Dr. Rabin's testimony that Dr. Matuziak was not a psychologist, but was in fact a pain doctor. That's shown by the decision, which in every case where he receives an opinion from a psychologist, he calls them a psychologist, except in the case of Dr. Matuziak, who he refers to as a doctor with a PhD. That's unfortunate, and that's material error. The specialization is a key factor in the regulations. And while the weight that different ALJs might give to that factor varies, in this decision, ALJ Gendrew ostensibly finds it very relevant. And every time he mentions one of the other psychologists, he praises them for their great credentials.
And remind me, what's Matuziak's PhD in?
He's a psychologist. He says so on his treatment record, on his medical opinion. And on top of that, he's a psychologist with special insight into people suffering from chronic pain. He served as the director of psychological services for a pain management clinic, I believe, for 17 years. And we submitted his CV into the record after the hearing corroborated that. So
let me ask you this, and I apologize if I missed it. I was doing a little bit of coughing, and you speak very quickly, Mr. Engelmeyer. You've got a lot to tell us, and so I'm trying to follow. Did you argue below that Dr. Matuziak's opinion should be given controlling weight?
We said that it could only be rejected under the good reasons standard, and good reasons apply to the ALJ's decision to not grant controlling weight. I agree that it is somewhat muddled, and there's more of a discussion of reliance.
Can you say that one more time?
Yes.
Okay.
The underlying briefing refers to the good reasons standard, which is applicable to the ALJ's decision to not grant controlling weight to the decision. I do think that the briefing focuses more on the discussion of the weighting factors as it moves along, but I do think that that was sufficient to preserve arguments related to controlling weight, especially because you
argue that the ALJ disregarded evidence because he didn't consider the treatment records of Ms. Yokish's back, neck, hip disorders. which you claim support Dr. Matsuiak's opinion. But the conclusions Dr. Matsuiak made that you claim the ALJ overlooked relate to her mental capacity, not her physical capacity. So why then would evidence of physical change necessitate a finding that she had marked impairment in her ability to understand or remember or carry out complex instructions, and limited her ability in judging complex work decisions?
So Dr. Matusiak's opinion does not rely on the imaging studies directly, which is why it's not part of the supportability prong, it's part of the consistency prong. That includes evidence that's not before the treating source directly. I'd say that with the imaging studies, I'm just relying on what the DSM-4 says, which is that it is an associated finding with this specific condition because it relates to physical problems, and the imaging confirms the existence of the physical problems. And although I think it's more important that the ALJ didn't address the P3 index results, and more important that he relied on mental status exams, many of which came from physicians rather than psychologists, against the advice of his own testifying psychologist, I think that those are bigger mistakes as far as the consistency analysis goes than the failure to address the imaging in the context of the psychological issues. Moving back, I think I'll reserve the remainder of my time for rebuttal, unless there's further questions.
We'll be here.
Thank you.
Okay. We turn to Ms. Huang.
Good morning, Your Honors. May it please the Court. Tae Huang on behalf of Social Security Administration. The ALJ in this case found that Ms. Yokosh was under disability since September 2017 rather than her alleged onset of August 2015. The core issue in this case is whether the ALJ properly discounted her treating psychologist, Dr. Matusiak's opinion, in arriving at this conclusion. And the answer is yes. She carefully considered Dr. Matusiak's opinion under the applicable regulations and provided several good reasons for discounting the opinion. Ms. Yokosh has not identified any legal reason that would require this court to remand the case. Turning to Dr. Matusiak's opinion, he opined that Ms. Yokosh had a marked to extreme limitation in performing complex tasks and a marked limitation in interacting with others. The ALJ used the regulatory factors of consistency, supportability, treatment relationship, and specialization of the treatment provider in discounting this opinion. The ALJ found that Dr. Matusiak's opinion was inconsistent with the medical evidence in the record. His review of the record revealed that Ms. Yokosh was repeatedly found to have normal cognition, normal memory, normal interaction, normal judgment, and appropriate affect and mood. The opinion was also inconsistent with Ms. Yokosh's own self-report. She reported that she had no difficulty interacting with other people. She also reported that her depression was only mild and her anxiety episodes were occasional and brief. In terms of supportability, Dr. Matusiak's opinion was not well supported by his explanation or Dr. Matusiak's record or record as a whole. And finally, as to the other factors, the treatment relationship and specialization of Dr. Matusiak, the ALJ recognized that Dr. Matusiak had a PhD and that he provided mental counseling to Ms. Yokosh for about a year. However, neither of these factors outweighed the ALJ's finding that Dr. Matusiak's opinion in substance was simply inconsistent with the vast majority of the record and unsupported by the substantial evidence in the record.
You know, there were a few kind of misses here, and I don't know why it strikes me, but it does strike me as odd that the ALJ takes the time to mention everybody else as a specialist, but not Dr. Matusiak. How do we determine that an error in an ALJ's order is just a drafting mistake, or, you know, a slight omission, or indicative of an error in the analysis, because our case law does say, you know, take into account the fact that someone's a specialist.
Your Honor, Dr. Matusiak specifically recognized that the ALJ specifically recognized that Dr. Matusiak was a PhD and that he provided mental counseling. And during the hearing, he asked specifically to Ms. Matusiak what kind of services she was receiving from Dr. Matusiak and whether she was a psychologist. And it is very clear from the record that she testified that she is a psychologist, that Dr. Matusiak is a psychologist, and that she received mental counseling. So taken as a whole, we believe that just the reference to the PhD and him referring to Dr. Matusiak as a doctor throughout his decision shows that the ALJ was aware of Dr. Matusiak's treating role in her mental health treatment.
You know, on appeal, you didn't address harmless error. Instead, you focused on adjudication on the error. They could not be decided on the harmless error grounds articulated by the district court.
Judge Rovner,
yes,
I'm sorry, Ms. Huang. You may have heard Judge Rovner, but we did not hear it come through clearly on the microphones. Can you repeat your question, please?
Sure. The government didn't address error. Instead, it focused on adjudication on the merits. And what I was wondering was, is there any reason that this case couldn't be decided on the harmless error grounds, which were articulated by the district court? That's how they ignored that.
Yes, Your Honor. Regarding the harmless error, we do not believe there was error to begin with in this case, and therefore the harmless error analysis engaged by the district court is irrelevant in this case. Even at the district court level, the harmless error was not the reason. It was just an alternative ground for providing, bolstering the court's affirmance. The district court affirmed that the ALJ did not err in assessing Dr. Matusiak's opinion under the applicable regulation, and that is sufficient grounds to reach a decision in this case.
Yeah, it was, of course, an alternative basis, but I did wonder why you didn't pursue it.
We didn't pursue it because it's not necessary in this case.
Thank you.
Thank you. The Dr. Matusiak's opinion was fully considered under the regulatory basis, and this court has held that if an ALJ discounts a medical opinion after considering the regulatory factors, the decision should stand so long as the ALJ minimally articulates his reasons for doing so. And the ALJ here wrote a 22-page meticulous decision. He provided ample support for all of his findings in the decision, and he more than satisfied the requirement, and the decision should stand. Unless the court has questions, we will rest on our brief and ask the court to affirm.
Thank you, Ms. Wong. Okay, Mr. Engermeyer, you've reserved some time for rebuttal.
So first, addressing the question of harmless error, as we noted in our reply brief, this issue was waived by the government on appeal, and that was with good reason. That's because the Step 5 testimony introduced at the 2019 hearing was objected to us as unreliable at the time. But most importantly, it related to jobs available to a person with a different residual functional capacity finding than exists in the current case. It's apples and oranges. And in particular, here, the RFC is significantly more restrictive. It's not just a coincidence that ALJ Gendrew never turned to the vocational expert in 2022 to ask if the government could meet its burden to show the availability of other work. Look at his restrictions, the only restrictions he added in addition to what Dr. Ghazi testified to, an unscheduled 2 to 3 minute break every 15 minutes that would total an off-task time of between 13% and 20% on a daily basis. I think that I've been doing this long enough, and more importantly, ALJ Gendrew's been doing this long enough to know that most vocational experts would not say that at the unskilled level where efficiency is key, that employers would tolerate that kind of inefficiency, assuming they tolerate changes in work posture throughout the day at all, which is a rare phenomenon. Turning back to the idea that ALJ found that Dr. Matusiak's opinion was not well supported by the evidence he cited, the ALJ never mentions the evidence he cited. He doesn't mention the P3 validity index test. He doesn't mention the heightened scores for anxiety, depression, and somaticization found through that test. He doesn't mention the endorsement of that test by his own testifying psychologist. All he mentions is that one of the conclusions reached in the test was that Ms. Yokush was at danger of losing control, and then criticizes Dr. Matusiak for not basically finding limitations based on the loss of control. But that was all purely hypothetical. It's a complete sideshow. He's attacking an opinion that Dr. Matusiak never offered and ignoring the opinion he actually did and the objective medical evidence that was supporting it. In terms of the question of whether it was harmless
and
error.
Mr. Ingermeyer, you'll need to wrap up.
Okay. Thank you, Your Honor. I would ask that the case be remanded with the time period for prior to September 2017 and affirmed with regard to the time period between September 2017 and November 2017. Thank you, Your Honor.
Okay, we thank both parties. We will take the case under advisement, and we will also recess briefly.
Okay, good afternoon. With the panel reconstituted, the court will move to its sixth and final argument of the day, and that's in appeal number 24-1994. Emily Lazaroo versus the American Board of Psychiatry and Neurology. Mr. Curley, nice to see you.
Good morning, Your Honors, and Happy New Year. May it please the court, my name is Philip Curley, and I represent the plaintiff's appellants in this case, Dr. Lazaroo and Dr. Akhtar. This court in Siva versus American Board of Radiology laid out the roadmap for what must be alleged to state a claim against a medical board such as ABPN for illegally tying the sale of its maintenance of certification, or MOC, product. Siva first found that certification products and continuing medical education products were separate, and also noted that the parties in that case didn't really dispute that. But Siva then went on to hold that in order to show that MOC products fell within the continuing education product market, 3 conditions must be met: that MOC contained educational content, that doctors earned CME credits from MOC, and the MOC was not redundant of other CME products. The Second Amendment complaint here, in this case, was plaintiff's first opportunity to address the holding of Siva. As set out in our briefs, plaintiffs here have plausibly alleged each of these 3 conditions of Siva. ABPN does not appear to seriously dispute this. Instead, it relies on stare decisis and a handful of other alternative grounds to affirm dismissal, all of which were proffered below by ABPN and none of which were adopted by the district court. ABPN also does not dispute that the district court ignored well-pleaded factual allegations, demanded a level of evidentiary detail not required by pleading jurisprudence, failed to consider all allegations and inferences in the light most favorable to plaintiffs.
Mr. Curley, what do you see to be the, just to jump right to it, what do you see to be the key differences?
Between, there are 2 key differences. One goes to the MOC product itself at issue in Siva in this case, and they are different and alleged differently. And the other is that the Second Amendment complaint here specifically addresses what Your Honor found lacking in the Siva complaint. So there are specific allegations here as to educational content. There are specific allegations here in this case with respect to cross-elasticity and the fact that doctors view MOC as being reasonably interchangeable with other CME products. And there are specific allegations in this case that did not exist in Siva on that cross-elasticity point. The plaintiff, Dr. Akhtar, actually used CME credits that he obtained from the ABPN product for licensure purposes. Also in this case, in this complaint, Second Amendment complaint, there are extensive allegations about the acceptance of MOC by states in whole or in part in satisfaction of their CME requirements. And also in the second amendment complaint here, but not in the Siva complaint, there are allegations about the AMA direct credit process whereby CME credit is earned, can be earned for purchasing MOC products. So those are the allegations, the legal allegations, I would say, that the court found wanting in Siva. As to the MOC products themselves, in Siva it was alleged that the MOC product there was principally a requirement that doctors buy CME products from others. There was no allegation about anything like assessment products or the ability to earn CME credits for assessment products. Those allegations are made here in this case and distinguish the actual mock product here from the mock product that was offered by the American Board of Radiology. Also, the mock product here has a waiver component, which did not exist in SEVA and was not alleged. And that component allows ABPN to waive CME requirements from other providers and substitute in their place CME from their own assessment products. And so there are significant factual differences between the mock products offered by the radiology folks and the psychiatry and neurology folks, even though they're both called mock or maintenance of certification.
Do you think, though, that the differences, can the Second Amended complaint be fairly read as to altogether take a physician out of a need to go into the market for continuing medical education?
I'm not sure it would take a physician altogether out of that market, but I don't think that's what is required. As Your Honor pointed out in SEVA, the missing allegation was, can you get CME credit for mock? And I think we clearly allege that to be the case. And in terms of altogether, that would seem to require that there be a complete foreclosure of competition, which was another finding or aspect of the district court's ruling. And we think the district court erred in that regard, because to state a claim, you don't have to, or to prove a claim, you don't have to allege or prove complete foreclosure, just restraint, a substantial impact on competition, which is what we have alleged in the Second Amendment complaint.
But can you focus on our reasonably interchangeable, the reasonably interchangeable analysis, which you buy into? You seem to be saying that both mock requirements, the activity requirements and the assessment requirements, are reasonably interchangeable with CME as far as consumers are concerned. So, if you don't buy into the language that Judge Scudder just used about altogether, how is reasonably interchangeable met when it seems to me kind of all the scenarios you paint still have doctors going to third-party vendors for CME at some point?
Well, that is true, Your Honor. And ABPN leverages its monopoly in the certification market to force psychiatrists and neurologists to buy their own mock product. The cross-elasticity requirement of reasonably interchangeable, again in SEVA, what was required was pleading that would, quote, permit an inference of cross-elasticity. Now, we have addressed that in the Second Amendment complaint. We have a section of the Second Amendment complaint that was not in the SEVA complaint titled mock is interchangeable with other products in the CME market. And again, Dr. Octor, I think, plaintiff here, is the ultimate example of that. We did not have a Dr. Octor in the SEVA case. In other words, he actually used the CME credit he obtained from ABPN towards state licensure. So that shows...
In part used it, right?
In part, but every CME product is only used in part. I'm not aware, nor are my clients, of any CME product that by itself establishes or provides all the CME credits required for licensure. I see I only have 30 seconds, unless...
Well, you want to reserve some time for rebuttal and just see how the dialogue goes on the other side?
Yes.
Yeah, that's fair.
Thank you.
Yep, you're welcome. Okay, Mr. Sullivan.
Good morning, Your Honors. Christopher Sullivan on behalf of the Appellee American Board of Psychiatry and Neurology. And where I'd like to start is with an analogy that you, Judge Scudder, asked the American Board of Council for American Board of Radiology in that oral argument in SIVA. And that was, and you might not recall it, and the other judges might not have heard it, was you used the analogy of, wouldn't you admit, American Board of Radiology, that if all you required for recertification was 10 bats and nothing more, and those 10 bats had to come from you, the American Board of Radiology, wouldn't that be a problem? And the answer is it would. But here's the difference. First, there's more than the 10 bags or the CMEs. There's a longitudinal assessment, 3 3-year blocks of that, or a secure proctored 10-year examination. There's practice improvement process that they have to go through, a 24-month 3-step process.
Yeah, so all you're doing with that, I remember it. All you're doing is saying it's a different product. To put on a complete parallel the market for continuing medical education to maintain licensure with board certification and all that board certification entails, 1, to receive, and then 2, to maintain. It's kind of an apples and oranges comparison. That's what you're saying.
That's not what I'm saying. That is what the American Board of Radiology was arguing. We're not pushing the 2-product argument, not because CIVA found that there was 2 products. That's wrong. What civil court said is they thought it might have been premature for the district court. So we didn't push that. We respected the decision. What I'm pointing out now is that in the interchangeability, there isn't interchangeability because there is the more, right? There's the things other than CMEs. But here's the key. It's the second point, the second distinction, is the ABPN doesn't make bets. And that's where every court, every district court, and every appellate court, including this court, has rested the dismissal on, is what they deem was no financial interest in the CME market. Whereas all of these CMEs come from third-party providers.
So you're saying physicians have to go into the marketplace. They can't shop within the board for CME because you don't provide CME.
Correct.
You have to go into the marketplace for CME and acquire it, and that's a competitive market.
Exactly, Your Honor. Yes. I would say it a little bit more strongly, and I can quote the language from CIVA that goes exactly to this point. It's quite a lengthy quote, and I've got it in the brief, so I won't. But the board, the American Board of Psychiatry and Neurology, doesn't compete in the CME market. It doesn't consume CMEs. It doesn't produce CMEs. It doesn't sell CMEs.
Right. Okay. So one of the points Mr. Curley's making is he's saying, well, there are some differences. It's not 100% factually aligned with CIVA. Do you want to speak to the differences he observes?
Yeah. So they finally highlight there's only 3 differences that they observe, and I think it's page 9 of the reply. One was that Mr. Curley mentioned was that there's educational content, which is in the civil complaint. That's not new. That is not a difference. That's in the civil complaint. The only one ostensibly that's a change is the fact of these statutes that allow some states to apply MOC, which is a 10-year process, for some CMEs. That's the only kind of difference between that and CIVA. And here's what I'd say to that, Your Honor, is first of all, those statutes were around well before the first complaint was filed in March 6th of it was 2019. Gone through multiple complaints, and every court that has looked at this, including this court in CIVA, has dismissed with prejudice at the pleading stage. So what that is telling you is that there are no set of facts. In other words, while that fact is new, the theory is the same. The analysis is the same. The relevant competitive market is the same as CIVA. Nothing materially has changed.
Let me ask you to respond to their argument that the complaint we're looking at today is really their first opportunity to address everything after CIVA. So this would not be the 4th bite at the apple that they're asking the district court for, but really a second bite. Can you respond to that? Why should they not have a second chance post-CIVA, particularly given some of the details they're asking us to take judicial notice of, but presumably they would fold into a new complaint?
Well, first of all, it's not exactly correct. While the briefing for the first amended complaint was pending, SEVA came down, and that judge, Judge Packold, I believe it was at the time, requested supplemental briefing on the effect of SEVA. So that was with the first amended complaint. Then they got the second amended complaint, and the only reason they got the second amended complaint, and this is in the district court's opinion, was we now know about SEVA and we're going to distinguish ourselves from SEVA. They then filed a second amended complaint, and other than the one peripheral factual issue of the ability in some states to get CME credit for MOC, there's no other distinction. And that's post-SEVA for the very reason to distinguish yourself from SEVA. I mean, the only difference with the SEVA complaint and the second amended complaint, I mean, they started out with the same draft. The ABR is in the original complaint against the ABPN. They just started omitting stuff. And that's why in the appeal, we had to go back to some of the first complaint to show that there is more to MOC than just CMEs, because plaintiffs just tried to get around it by taking it out. But they didn't add anything. There's no new analysis, no new claims, no new theories, legal theories. They're identical to SEVA.
So in response to the particular point that Mr. Curley is making, that the difference that he's emphasizing is whether you want to term it a waiver of a need to get a certain number of credit hours or credit for credit hours. Okay, he's saying it is different because there is some kind of credit or a waiver of a need. So you have this 90-hour requirement, there's a 16-hour waiver or credit. You know, it takes you down to 74. You all know, you know what I'm talking about.
Mm-hmm.
Okay, all that. So when I look at that, I say, well, yeah, that we didn't have to speak to that. The court didn't have to speak to that in SEVA, but why is it a distinction with any difference? Because the 16 hours that are waived, the 16 hours that are credited, pick the verb you like, okay? I don't know that shows cross elasticity, because the 16-hour waiver or the 16 hours of credit, it seems to me, is the fruit of taking an examination or going through some kind of continuing, kind of testing refresher with the way the mock product works that way. I don't know that it really tells us anything about a risk to competition from tying in the CME market.
Exactly right. It doesn't add anything, because it rests on that point that I started with, right? If the ABPN had financial interest in the CME market, if it competed in the CME market, we would have a different case. But they don't, and that goes to price elasticity in the competition. So it doesn't matter whether
they don't supply CME.
We do not supply, ABPN does not supply CME, doesn't produce CME, doesn't distribute CME.
Yeah, so we'll see what Mr. Curley says. I mean, you have to take that factual difference and say it's of legal significance. That there's
or material difference to a legal premise, rather than just a peripheral fact.
Okay, anything further you want to add?
That's it. Thank you.
Okay, you're quite welcome. Mr. Curley.
I'm going to go right to that last colloquy. ABPN does produce and sell products for which doctors can earn CME credits, which in SEVA was the second condition that the court found to be missing.
What's the product? The successful completion of the exam?
The product is either the 10-year exam,
yeah,
as Dr. Akhtar took, and you asked counsel about going into the market, and and how that involves. Well, as a result of Dr. Octor being able to use those 60 credits from the ABPN product, he didn't have to go into the market to buy those 60 credits from other providers. That's the harm to competition. But to get back to your question, in addition to the 10-year exam for which credit is earned, there's another product that's part of MOC, which is the 3-year articles pathway. And so that's also a product for which doctors can and do obtain CME credit.
Why should we ignore the fact that Dr. Octor, he was given, he did that direct credit transaction.
Yes, ma'am.
He got the 60 additional credits, but that wasn't everything he needed. He still needed more that he couldn't get from ABPN. He still had to go to the CME product market and get some additional CME from third-party vendors.
For licensure, that's correct. But again, that's the same with every CME product. There's no CME product of which we are aware that provides the 150 credits required by Illinois, for instance. Doctors put together a portfolio of CME credits to qualify for their
But so
licensing.
long as that's the case, why don't we have a problem on the lines of substitution and replaceability and so forth, so on?
Well, first of all, we're at the pleading stage. All we need to do is make allegations that permit an inference. But it's not. The problem is that, again, in Dr. Octor's case, instead of buying those 60 additional credits that he needs for licensure from other CME providers, he used the credits he got from MOC and from ABPN. So that is the restraint on competition. You do not need to be perfectly fungible. You do not need to be 100% substitute, especially at the pleading stage. And we think we've alleged more than enough facts to show that doctors view MOC as reasonably interchangeable with other CME products. And in fact, that's not just a legal conclusion. Dr. Octor did that and so specified in the Second Amendment complaint. But it's the same with, remember, there are two ways that doctors can use MOC for CME credits. One is this direct credit, which we've been talking about and spending most of our time, I think, talking about that, and that's the Dr. Octor example. But in addition to that, even without having to get the direct credit, many states accept MOC in place of the entirety of the CME requirements. So that is equally as important, or maybe more important in substitutability than the direct credits.
Okay. Okay.
Thank you very
Early,
much.
thanks to you, Mr. Sullivan. Thanks to you, your colleagues as well. We'll take the appeal under advisement.
Thank you.